part heard appeal in the matter of the King on the application of Thakrar and Secretary of State for Justice.
We're grateful for the robe dispensation.
Good morning. Yes, it seems to be even hotter than yesterday.
First thing, good news, we've agreed the table. Can I hand it up?
Oh, yes.
Actually, does the court want spare copies for anybody else?
If we have two judicial assistants in
Yes.
court, so if they're
Send them electronically.
yes,
Yes, is there a
they
particular
of course are
email
entirely
address?
digital, but if you send them to my clerk and ask him to send them on,
Could my lord just if you could have a piece of paper with the clerk's email address on it, that would be great. We haven't had any. No, we haven't had any. I haven't seen any contact from my lord's clerk prior to this hearing.
David.James2.
David.
James2. Justice.UK.
I'll come back, if I may, to the detail of the table when I go through the documents.
Let me just read it.
Yeah, it's a two-sided piece
Oh,
of
I see.
paper.
I thought I read somewhere that he was able to associate with two other prisoners. On the
Yes,
house.
another is the position is set out in more detail in the post-hearing submissions, which is what my lady probably has in mind, in supplementary bundle. I think from recollection it's page. Let me just get it. Hold on. Tab 1. Page 7, paragraphs 3 and 4, and footnote 1.
Anyway, these are agreed facts.
These are agreed
Thank
facts,
goodness, yes.
and I will, in due course, take you to the many of the documents in the table and do my best to explain the footnotes, which show some date anomalies on the document. It may not matter in the end. I invited the court overnight to consider 3 cases, Borgas, Schvidler and Sneddon. Can I identify the 3 propositions which we derive from those authorities and why they matter? The first proposition is that the function of the Management Committee is to assess risk and the appropriate management of the group of prisoners held under Rule 46. It is not to determine a disciplinary or criminal charge against each prisoner. And the reason I highlight that is that at times, my learned friend's submissions slipped into suggesting that when the committee took into account evidence of threats made by Mr. Thakrar, evidence, for example, in anonymous records, that should somehow be discounted, should have been discounted by them and should be discounted by you because the allegation hadn't been proved as if following a contested disciplinary adjudication. But Lord Reed's judgment at paragraph 92 in Borgas shows that that can't be right.
But if it's the case that, say, 2 or 3 months down the line, there has not been an adjudication, that it just hasn't been brought forward,
Yes.
would that be something to be taken into account?
My lady, incidents happen with prisoners on a daily basis,
Yes.
many of which could be the subject of a disciplinary adjudication. If every single time such an incident happened, but there was not a disciplinary adjudication, the relevant risk management committees within the prison or within the Secretary of State couldn't take it into account. That would make life very difficult indeed. I mean, for example, as I'll show you, one of the things mentioned in Mr. Worsman's statement is that a reason why Mr. Thakrar could not, for a long period of time, be allowed to be in a room alone with a psychologist was because he had inappropriately touched a female psychologist within the prison. Now, that wasn't, so far as I can recall, the subject of disciplinary adjudication, nor was every other threat, aggression, manipulation, all of which would in one way or another be a breach of the prison rules, brought to disciplinary adjudications. And as I say, thousands of such incidents happen every day in the prison service.
I mean, you won't have seen, but online we all saw when you said that, Mr. Thakrar shook his head about touching, when you said what you said about touching the psychologist. So that illustrates that this is an allegation which has been made.
Yes.
Which he does, I'm assuming from his reaction, denies. How is that then treated in line, following what Lord Reed said at paragraph 92?
It has to be weighed into the balance in a risk management exercise. The management committee can take into account the cogency of the evidence, the fact that somebody's denied it, but to make, it's not its function to make findings of fact as if following a disciplinary adjudication.
No, but if it's not referred to in the reasons which he's given, if nothing is said about it, how is he meant to be able to deny it? It's
My
there
lady,
in the
I'll show you.
report.
I'll show you the documents where these matters are made clear.
Okay.
I mean, in other areas, forgive me for drawing on my own experience in other areas, in child protection, you have to make decisions about risk for future. The case law is clear that you do that on the basis of proven fact in the past. But that doesn't happen here.
That's why I drew my Lord's attention and the court's attention to what Lord Reed said in paragraph 94.
Yes. But Lord Reed doesn't actually say how it's done, does he?
We'll see that from the
Okay.
My second proposition.
Sorry, just pause for breath a moment. Let me look at the relevant paragraph of raw gas.
My learned junior, Mr. Grandison, who is steeped in knowledge in this area, also tells me there's a decision of the Supreme Court called Pierce, P-E-A-R-C-E, P-E-A-R-C-E, which we'll get copies of, which says, in pithy terms, the parole board, when deciding upon the question of risk for the purposes of deciding whether somebody should be, I assume, due to open conditions and or released post-tariff, does not have to base its views on express findings of fact. So something similar. We'll get copies further.
Well, of course not. But if they don't say to the prisoner, there is this entry on file which we propose to take into account. What have you got to say about it? That would be extraordinarily unfair.
But as my lord will see, to answer that observation and my lady's parallel observation a few moments ago, the reports where these incidents are noted in the report to the management committee are seen by the prisoner, and you will see, consistently with Mr. Thakrar shaking his head before as he shakes it now, that every time an allegation is made against him of one kind or another, he writes in the margin something like false or nonsense. So the committee, and the committee will see that denial of the allegation. But it doesn't follow from that the committee has to proceed, and with respect it would be a misdirection for this court to assume that it should proceed on the basis of each and every allegation having to be proven to any particular standard or at all. It's a risk evaluation exercise.
Is that true of all allegations, or are there certain allegations which do have to be established on a finding of fact basis, as it were, before risk can be assessed?
Well, my lord, I don't, without instructions from those behind me, I prefer not to answer that question. Tentatively, what I might say is there might be a situation in which the whole of a decision to keep somebody, for example, in Category A conditions, or the whole of a decision to, for example, to keep somebody in the CSC at all, or segregated from other prisoners, all revolves around one contested issue. And in those circumstances, I can see that the position might be different. But in this case, as we'll come to, But quintessential point is Mr. Thakrar's refusal to engage and its relevance. And that was undoubtedly said to him and evidenced over and over and over again. So insofar as it was necessary for the committee to make a finding that he was refusing to engage, A, they had plenty of evidence to that effect, and B, they did so. My second proposition, made clear from the Court of Appeal passage in Snedden that I gave the reference to, among many other cases, is that in discharging its risk assessment and management function, the committee who acts on behalf of the Secretary of State obviously has very significant expertise and comprises a wide-ranging body of people who are considering a wide-ranging set of evidence before them. We'll see that when we go to the documents. And my third related proposition, clear from the recent decision of the Supreme Court in Schwidler at paragraph 123, is that when evaluating the lawfulness of the management committee decisions, this court is required to take into account, or as my learned friend fairly put it, respect the institutional expertise of the management committee, notwithstanding that in the context of an Article 8 proportionality undertaking, it's for the court itself to assess proportionality. The two principles are not inconsistent. So under Article 8, it's for you to assess proportionality, but you can do so giving due weight and deference to the institutional expertise of the committee. That's what I wanted to say on those legal principles by way of introduction. I now want to confront grounds 4 and 5, which will entail in a minute a detailed analysis of the documents, many of which you have not so far seen. But again, before I do that, there are some further legal principles to establish. First, to succeed on these grounds, the appellant faces the high hurdle set out in Haringey and Ahmed of having to show that there was no evidence on which the judge could properly or rationally have reached her conclusions as to what the MC decided and the reasons given for their decisions to Mr. Thakrar. Just to remind the court, although I'm sure you've seen it many times, Haringey is at Authorities Bundle tab 9. And the page I'd like to go to is 224. If my lady and lords could read from paragraph...
Sorry, I think that, yes, I'll ask Lord Justice Baker to act as actor, but our colleagues who are limbering up for a 10:30 hearing don't know that we'll have the door in.
Well,
Sorry, A9, page 224.
yes, A9, page 224. If the court could just read from paragraphs 29 to 31. This will all be well familiar material to the court.
Not now, I mean, George, just tell me if there's
Mr. Armstrong yesterday said that there was what he called an adjusted Haringey test in this case. And I think he said that was because of the length of the ongoing detention. And I'm not sure that's what he meant, but whatever he means. Sorry? It's the delay. I'm sorry, I hadn't appreciated that. It's because of the delay in judgment. But we obviously do not, we're not here to support the length of time that it took the judge to reach a judgment. My submission will be that given that the case turned on the documentary records, however regrettable that delay obviously was, it did not materially impinge upon her analysis of the evidence, nor leads to a different test on appeal to that set out in the passages I've just taken you to. Secondly, and perhaps more importantly, it is common ground in this case, as it was below, that the Management Committee was obliged to consider whether Mr. Thakrar should remain segregated in a designated cell, as well as remaining within the small CSC estate under a Rule 46 direction more generally. But, and this is an important but, it does not follow that those two matters were unrelated to each other, or that two entirely discrete sets of decision-making process had to be undertaken by the committee each month and recorded as such in their minutes. In particular, as the court will appreciate, given that by definition, a prisoner held in a designated cell will not be allowed to associate with other prisoners, if the Management Committee have considered the appropriateness of Mr. Thakrar being held in a designated cell, as they regularly did, rather than in a CSC unit on mixed unlock, and have concluded, as they
you're saying this in such a way that as though you want us to write down every word, but you're going too fast to do it. So start the sentence again.
Yes. Given that by definition, a prisoner held in a designated cell will not be allowed to associate with other prisoners, it follows that if the committee have considered the appropriateness of Mr. Thakrar being held in a designated cell, rather than in a CSC unit on mixed unlocked, and have concluded, as they regularly did, that this was the appropriate location for him. So proper inference is that they are aware of and have considered that he is not going to be allowed to associate with other prisoners. A very long sentence, but that's an important point. I hope my lords and lady were able to note it.
Right.
I think we must have got there.
Thank you. The next legal principle I wish to rely upon under grounds 4 and 5 concerns how the relevant documents that I'm going to be showing you are to be read. And the principle is identified in our skeleton argument at paragraph 46.3. If you could turn that up. It's core bundle, tab 6, page 94. Statements of reasons should be read fairly and in good faith and as a whole, in a straightforward, down-to-earth manner, and as if by a well-informed reader who understands the relevant issues. That's a reference to the judgment of Mrs. Justice Lang in the Wokingham case, and the reason it's not in the bundle is because it's an agreed principle. We did our best to comply with the imperative not to include in the bundle authorities which were for propositions that were not in dispute.
Yeah.
How
could 46.3 be in dispute?
What one would hope not. In particular, if you were to look at that passage in the judgment of Mrs. Justice Lang, it draws on House of Lords and other appellate authority. the application of that principle in this case is again very important. In our submission, one cannot read each set of minutes of the management committee or each of the pages of the feedback reasons given to Mr. Thakrar in isolation from the reports that were before the committee, which in fact Mr. Thakrar saw and commented on. They have to be read together. Nor can one read the documents as if each month the management committee was considering the issue of Mr. Thakrar's segregation as if for the very first time, in isolation and divorced from all the previous history. In other words, there's no proper inference that they have institutionally forgotten that which they considered the previous month. So even in the months where they don't say, and Mr. Thakrar is appropriately held in a designated cell because he's refusing to engage, as they do on so many months, the idea in that month, the matter slipped their mind, or the idea that Mr. Thakrar wasn't told regularly, as he was, that that was why he was continuing to be kept in segregation, is fanciful.
The fact they've used the same phrase over and over again doesn't mean that they haven't addressed their mind.
Absolutely not.
But by itself, it doesn't mean they haven't addressed it.
Certainly doesn't, or that's not a proper inference to draw. Next and relatedly, can I address, in the learned friend's submission, that the reasons given to a prisoner for his ongoing segregation need to become increasingly detailed and more compelling as time goes by. That submission is grounded in the case law, in particular the judgment of the Strasbourg court in Ramirez-Sanchez. Ramirez-Sanchez concerned a prisoner held in solitary confinement for 8.5 years in very restrictive conditions, where, as I will show you, the reasons for his ongoing solitary confinement were certainly no more detailed than they were in this case, and often significantly less detailed, and where there were less frequent reviews every 3 months, not every month, and where, nonetheless, in all the circumstances, the Grand Chamber did not find there to have been a breach of Article 3. If you could turn up Authorities Bundle, Volume 2, Tab 20. You can see the fact that reasons are given every 3 months from paragraphs 15 of the judgment onwards. It starts at page 824. The parties, it says, have produced a series of decisions requiring the applicant to be held in solitary confinement for successive 3-month periods. And then there are a series of reasons given or recorded in the judgment. I'm by no means going to take you through the whole of the 8.5-year period because that would take far too long. But just to give you a flavour, paragraph 16, the first decision was taken when the applicant was first detained. It consists of a form in which the following boxes were ticked: need to prevent communication with one or more other prisoners, tick; undermining of order and discipline, tick; no observations by the applicant. Paragraph 17, second sentence, reasons was the same, and there's a reference to the applicant's observations. Paragraph 18 over the page, 825, decision in January the following year, citing the same reasons. Paragraph 19, same reasons, etc., etc., etc. So a tick box exercise over and over and over again, same formula, yet
Does the Grand Chamber make a specific observation about that point?
Well, we can see what, I mean, and in due course, my lord will wish to read all the formulaic reasons every 3 months. And what one gets,
Well, I'm not sure about that. It doesn't come down to what was said by our Supreme Court in Shahid case. I mean, speaking for myself, whether reasons have to be increasingly detailed and whether they have to be increasingly compelling are two different points.
I would respectfully agree.
And the Supreme Court say in Shahid that in effect they have to be increasingly compelling, or at least the seriousness of the risk required to justify segregation has to be greater as time goes on. Doesn't mean to say that in year one this much detail is required, and in year two more detail is required.
I would respectfully agree.
Yeah.
And can I confront that principle and the way in which my learned friend seeks to develop it in his submissions, which was by saying that as time went on, it became ever more incumbent on the Secretary of State to, quote, think creatively. That's how he translated, I think, the Shahid obligation. Sorry? Ah, yes, he says think intelligently.
Yes.
Maybe think creatively is another word as well. And I have two responses. First of all, whether under Shahid or otherwise, or under Ramirez Sanchez or otherwise, we do not accept my learned friend's characterization of what the obligation entails. There may well be some cases where the relevant matter blocking a prisoner from progressing lies within the control, or largely within the control, of the prison authority, Secretary of State. And where, as time goes on and the impact on the prisoner increases, the obligation to unblock the problem, whatever it may be, steadily increases. But in a case such as the present, where the route to progress lies in the hands of the prisoner himself, and where he has been told over and again what is required, and where he has been offered over and again a variety of solutions to help unblock the problem, as I will be showing you in the documents, and when there is no good reason, as there was not in this case, for the prisoner not to engage in a risk assessment process that would allow his risk to others to be properly assessed, it is not, in my respectful submission, legally incumbent on the Secretary of State to offer ever more creative, or as my learned friend would characterise it, intelligent solutions to the prisoner's own intransigence. Secondly, in any event on the facts, when I show you the documents, you will see that Mr. Thakrar was offered, over time, a wide range of possible options to accommodate his various demands, to encourage him to engage with the local MDT and with psychologists, and to facilitate an assessment of his risk, including by offering him the opportunity to be assessed by Professor Gruber, who he himself wanted some years previously, but once it was suggested to him by the prison service, he declined, all of which he said no to. So this is not a case where the Secretary of State has stuck his head in the sand and said, we're doing nothing to try and help you get out of the situation in which you're in. The position is not that. And I'm now going to establish what I've just asserted by taking you to the facts. The starting point is, of course, the claimant's conviction in 2008 on several counts of murder, which led to a very long tariff indeed. Can my lords and lady turn back to the judgment that is of Mrs. Justice McGowan, 4 bundle, tab 9, paragraphs 46 to 48.
He was convicted on a joint enterprise basis of 3 murders, 2 attempted murders, which in being carried out by his brother, he was given a life sentence with a 35-year term. Is
Yes,
that
my
right?
lady.
I mean, that's, in short, that's what he was convicted of.
Yes, my lady. The next event,
I want him to understand, because I know it's a point that he feels strongly about, that we understand that his conviction was on a joint enterprise basis.
yes. Yes, my lady. The next event, which led to Mr. Thakrar being placed into the CSC system under Rule 46, was his serious assault of 3 prison officers in March 2010. I've already shown you the parts of the judgment below, paragraphs 50 to 56, where the judge deals with the relevance of that 2010 incident, none of which is appealed in this case. I do want to show you some further evidence about that 2010 incident that we haven't yet looked at. In the supplementary bundle,
Can you just remind us how old was he in 2008 when he was convicted in 2010?
somebody will give me his age. I think he was in his mid-20s.
Mid-20s, yeah.
So he was an adult, my lady.
Yes.
Lady, 1987 born.
He was older than 18.
Yes, I mean, yes.
21 when he was convicted.
Yeah.
He was convicted in 2008. He was born in 87. He was in his
23
20s.
when he
23 when he assaulted the 3 officers. If the court turns, please, to the supplementary bundle, to tab 4, witness statement of Mr. Worsman, page 98. Paragraph 39. Could the court read paragraph 39 and paragraph 40? Page 98, supplementary bundle.
Did you say to 41? Is that what you said?
40, actually.
40.
Yes. The 41 and following has already been covered in the judgment, so it would be repetitious for me to ask you to reread it. But you can see for yourself the seriousness of the incident. As I mentioned yesterday, although Milone Friend's case below was that the incident should have been ignored in light of the acquittal by the jury, that submission was rejected by the judge and has not been appealed to this court. So that's an important bit of background.
Did the Ombudsman become involved because Mr. Thakrar made a complaint that his segregation, all his being subject to Rule 46 at all, was inappropriate?
Yes, that was Mr. Grandison's recollection is in line with my own. And in the court below, the Ombudsman's report was before the judge. Mr. Thakrar had a risk alert on his file. There was something called a risk alert for risks to staff, and he complained about that risk alert. Said, "I'm not a risk to staff because I was acquitted by the jury," and the Ombudsman rejected that complaint. case in the Supreme Court. So there was no challenge to the judge's approach to the relevance of that incident in this appeal, nor was there ever any challenge to the lawfulness of the decision in 2010 to place Mr. Thakrar into the CSC system under Rule 46. And so, as Mrs. Justice McGowan rightly said, she had to proceed on the basis that that placement was itself lawful. In other words, the appeal before you has to proceed from the starting point that Mr. Thakrar has at all material times been lawfully the subject of a Rule 46 direction, placing him into the CSC estate, which, as Mr. Worsman's evidence explains, and I'll just give you the references for now, paragraphs 5 to 9, comprises just 68 spaces across the whole of the prison estate in a combination of units and designated cells, and is designed to manage some of the most challenging prisoners in England and Wales in very tightly controlled conditions. So we have to proceed on the basis that he is suitable for that kind of very tight control.
Could I just go back to the incident?
Yes.
The bottling incident.
Yes.
You explained how, following what Lord Reed said in August, that how allegations about what happened in prison are not treated in the risks arising from that, they're not treated in the way that they are in the sentence. How do you say the prison service treats this sort of situation? Presumably it does arise in other cases, whereby an incident in prison leads to a criminal trial with a result, in this case acquittal. Is there a policy or practice of how it
I
is
don't know
treated?
whether there's a policy or practice, but on the fact of this case, and obviously we don't have reasons from the jury, but there was no serious contest that Mr. Thakrar stabbed a woman in the back as she ran away from him with a broken glass bottle. The question was that in self-defense? Even if it was, and even if, as Mr. Thakrar asserted at trial, it was to do with the PTSD which he had suffered from a previous incident, or a combination of incidents, including, I think it was said, his own involvement in the joint enterprise murder in 2008, which he said gave him PTSD along with other things in prison.
It's very common.
My lady, that may be so, but whether or not that is so doesn't mitigate the risk that he presented. Whether or not he stabs somebody in the back because he's just being aggressive, which is obviously a very simplistic approach, or because of a combination of many other factors. And I'm not going to speculate what they all were, but they might have included some impact on his mental health condition. I'm not accepting the diagnosis of PTSD was appropriate because that's not the Secretary of State's position. But nonetheless, whatever the reason, as the Ombudsman rightly held, this was plainly relevant to his risk. It didn't require the Secretary of State to form a view to second guess what the jury had decided.
So really, are you saying the criminal proceedings were irrelevant? You go as far as that?
No, I wouldn't go so far as that. I mean, I couldn't go so far as that, because if he'd have been convicted by the jury, my position or the Secretary of State might be able to say, well, you can't go behind that.
Okay. Yes, but he wasn't.
No, but nor was it seriously contested, and certainly the Secretary of State didn't have to proceed on the basis that he didn't stab somebody in the back and didn't seriously assault two others.
So
There was no factual dispute that he was the person who had used a bottle. But when you said the question for the jury was, had he acted in self-defense? That's boiling it down rather. The judge's directions to the jury would have been rather more sophisticated.
I'm sure.
What was he? Did he go beyond what he reasonably perceived, given his own mental state, etc., etc.?
Yes.
You're entitled to say, as the Ombudsman said, that the PTSD factor is relevant.
Well, the incident was relevant.
Well, the incident is relevant, and you say you were rather suggesting from your choice of words and tone of voice that the finding of acquittal was absurd, but that's not the
Certainly don't need to go that far.
no, you don't. Right.
I'm also anxious. I mean, I'm happy to continue this discussion genuinely because it's A, interesting, and B, maybe relevant. But on the other hand, the judge found what she did in terms of the relevance of the incident in 2010.
And there's no appeal.
And there's no appeal.
No.
I also, as I said before, place weight on the fact that there's no challenge to the lawfulness of the decision to place him into the CSC estate in the first place, which is designed under the policy to deal with the CSC policy to deal with the most challenging sets of prisoners in the estate. I'm not going to take time over it, but if my lords and lady turn very briefly to the operating manual, supplementary bundle tab 9, picking it up at page 374, you will see at the top of page 374 there's a reference to a whole freestanding prison service instruction all about referral, PSI 42/2012, which provides the necessary information on which to base a decision whether to refer a
Sorry,
prisoner.
where?
SB 374 top paragraph.
Top paragraph.
I'm showing you the referral manual. My recollection is that was in the bundle below. It hasn't gone into the bundle now. Doesn't matter. In due course, you may wish to look at the following paragraphs about the process leading to a referral. As I say, none of that is under challenge. And you will see, for example, at page 376, under the heading Pre-Selection Assessment, at item 3 in the indented passages, that the assessment period is a 3-month one. Although in total, as appears from the next passage, the whole thing takes about 4 months. So this is a very detailed assessment. So in terms of the timeline, Mr. Thakrar starts to be held under this regime in 2010. And there is no challenge to the lawfulness of his being held in that regime for 11 years, from 2010 to April 2021.
Sorry, you say held under this regime. You mean held under the CSC regime?
Indeed, no, not segregated from
Not
other prisons.
segregation.
No.
No.
But the point I'm making, my lady, is that Mr. Thakrar is not somebody who has, I'm putting it in extreme terms, gone from being a Category D prisoner with wide-ranging privileges and access.
That's not what we're looking at
No,
here.
I know.
What we're looking at here is an obviously challenging prisoner who's sufficiently challenging to be moved into the CSC estate, but who is nevertheless within that very restricted estate being segregated
I understand, my
for
lady.
long periods.
I understand, my lady.
We're
But
looking at whether the reasons for that are sufficiently articulated.
my lady, with respect, the baseline is important. If this was a prisoner who'd gone from Category D to CSC segregation, Mr. Armstrong would be saying that's a massive invasion of his Article 8.1 rights.
He's not saying that, and he can't say that because Mr. Thakrar was a Category A prisoner from the off, as any person convicted of murder is, and then he was moved for good reason into the CSC, or at least for reasons that are not being challenged, into the CSC estate. It's not what we're dealing with here. What we're dealing with here is his segregation within that estate.
Can I then turn to that period, my lady? Starting in April 2021. Can I just, before I do so, pick up one passage in Mr. Worsman's statement that is relevant, because it covers the preceding period that is not under challenge, but you'll see why it's relevant to the period that is under challenge in a moment. So this is Mr. Worsman's statement, supplementary bundle tab 4, paragraph 46. There's a reference to him being reluctant to work with prison psychologists, and I'll obviously be showing you that in very great detail in a minute. Then paragraph 46 says, he's also assessed as not being suitable for one-to-one sessions with lone professionals, having previously made sexual references to and engaged in unwanted touching of an HMPPS psychologist. And the reason I draw you to that to your attention is that, for example, in Dr. Cresati's report that I'll have to come back to, supplementary bundle page 66. She says, top of page 67, I note there has never been a threat to a civilian member of staff. And you will also see when we come to it that in the compact, or rather the consent form drafted by Mr. Thakrar, on the basis of which he was prepared to undergo risk assessment, he says, you, the psychologist, have to agree that I've never threatened anybody.
Where was the passage in Dr. Cresati's? I missed
Top of page 67,
I'm sorry.
line 3.
I don't know the answer to this. Can a prisoner ask for an adjudication on something that he knows is on his file and being brought up repeatedly in risk assessments? Can he ask to challenge it? Can he ask to have an adjudication?
Yes.
I know that DJMCs regularly go into prisons to do adjudications on
Yes, no,
serious matters.
I'm told that obviously he has the right to appeal the outcome, but he doesn't have the right to instigate one.
How does he challenge this?
How does
What's
he challenge
asserted in
something
paragraph
that's on his file?
46,
Well, I'm not.
if he wanted to?
I'll have to take instructions.
I mean, obviously, something like this is very serious, and you're rightly drawing our attention to it and saying that Dr. Cresati wasn't told about it, and that he's got some unreasonable thing in his compact, which, because of this event that is on his file as having happened. But if he denies it, and it's constantly being used against him, how is he supposed to challenge that?
Well, my lady says it's constantly being used against him. What it's being used to do is to protect the female psychologists in the prison, many of whom have felt manipulated by him, many of whom have left after having worked with him.
But well, you assert that from implicit in what you're saying is that it is true. He denies it. He says it's not true. How does that get it?
But my lady, that goes back to the point I made earlier.
Yes, it does. Which dismayed me at the time you made it, because if these matters are rolling into a risk assessment, and some of them will be more serious than others, this is very serious.
My lady, risk
How does
assessments
he-
are carried out in all sorts of contexts in the prison service every day. You're risk assessed to whether you can go to the gym. You're risk assessed as to whether you should move from category B to A or A to B, B to
We're not
C.
talking about that type of risk
But
assessment. These
to the-
are a handful of prisoners, as Mr. Worsman tells us, a very small number of prisoners within a very restricted estate. And this sort of thing is being used to, you are pointing to this, to justify decisions to keep him segregated within that unit.
My lady, doubtless it's important to Mr. Thakrar, but if this court were to rule that there is some unlawfulness, not pleaded as any part of this appeal, consisting in a lack of mechanism to determine findings of fact, contrary to what Lord Reed.
There's no question of that. I'm just interested
Well, but-
in understanding how matters like this, which feed into a risk assessment, are addressed. Can be addressed.
Because this wasn't part of the appeal, I don't have full
No,
instructions
alright.
as to how.
No, I understand that.
Just the allegation in paragraph 46 of Mr. Wordsworth's statement is of a different nature from the allegations which led to his conviction on the class of incident. So
There are all sorts of incidents taken into account by the management committee of a varying range of seriousness, with a varying range of evidence. Some depend upon reporting by an officer. Some are recorded on body cams. Some are noted in the NOMIS record. Some are not. There is no. I can't give a kind of one size.
So your case is, your position is straightforward, isn't it? In the context of the prison, the order and discipline of prison requires allegations of the sort to be, as it were, taken as established, without any requirement for proof or adjudication.
I wouldn't put it as boldly or as simply as that, my lord. I certainly wouldn't say an allegation can be taken as correct without any proof. If there was literally no evidence, if there is a body cam record of, leave Mr. Thakrar to one side for a second, of a prisoner hitting an officer, the fact that but the prisoner says, I didn't do it, the body cam imagery has been fabricated. It can't seriously, I'm sure, wouldn't be seriously suggested that
There's no sort of formal requirement like reasonable grounds for believing, which you do get in some risk assessments.
I mean, in a public law context, the classic approach would be: was it Wednesbury irrational for the decision maker to take into account, as part of its risk evaluation exercise, the evidence of X? And in my respectful submission, even in a convention context, the materially different standard does not apply, because when you give due weight to the institutional competence of the Secretary of State in managing risk, you can't, the Secretary of State can't be expected every time to set up a mini trial on the facts of every single matter throughout the range of seriousness that must feed into his or her assessment of a prisoner's risk.
We seem to have strayed from grounds 4 and 5.
Yes, well, I'm only.
And this may be our fault. We're not conducting a public inquiry into all aspects of the prison regime, either in Mr. Thakrar's case or generally. Grounds 4 and 5 are what did the committee actually make a decision to
Keep
place
Mr. Thakrar on
Mr. Thakrar
segregation.
within segregation
And were the
and
reasons sufficiently
designated
communicated?
cells? And round 5 is were those reasons communicated to?
Can I now turn to address that on the
Yes.
documents? Can we start, please, with the letter at SB 114?
This is the 7th of April.
Indeed.
Letter which starts it all.
Page again.
SB 114. You could just reread that. Perhaps, I'm sure you've read it several times. Can I compress it into 3 reasons that were given to him? First, his refusal to engage with the clinical team to allow his risks to be addressed. Secondly, the recent monitored call in which he was recorded as threatening to assault his prison offender manager. In other words, by saying you can only be a certain level of stupid before you need to have someone put your fist in their face. He will not learn any other way. On any view, that is a threat of violence against a prison officer. And third, his overall challenging behaviour, which had affected both staff and other prisoners on the unit. Further detail concerning each of these matters is set out in Mr. Worsman's statement at paragraphs 58 to 65. I've already asked you yesterday to read paragraphs 48 to 54, but I haven't yet shown you paragraphs 55 and following. Could you pick those up at supplementary bundle page 102? If you just pick it up at paragraph, right, could I ask the court to read the whole of 55 to 65? It will take a couple of,
Yes.
at least a couple of minutes.
Where do you want us to read up to?
Just the end of 65. And if you had a chance to do that, those passages speak for themselves. The only point I would wish to draw out from paragraph 63 in particular, and it's perhaps an obvious point, which is that deciding where in the CSC estate Mr. Thakrar should be held and in what conditions, and whether he could be safely allowed to associate with others, is obviously a complex, or what Lord Justice Laws might once have called a polycentric decision, and not confined to looking at matters just from Mr. Thakrar's perspective. Mr. Armstrong yesterday, when discussing the concept of what deference this court should pay to the decisions of the management committee, said something close to, you're in as good a position to assess these matters for yourself as is the management committee, and with great respect, that cannot be right. However experienced this court is, it is not in the same position as a body that regularly considers the management and risk presented by prisoners. Can I now turn to the first set of Management Committee documents from April 2021 and start at page 144 of the supplementary bundle. Some parts of this report relate to the period before the move to the designated cell, and some parts of this report relate to the period after the move. So 144, for example, in parallel to the upper hole punch, has a report from Rachel Sales, senior registered psychologist, covering the period 6 March to 2nd April. And in the second passage under her report, it says, since becoming Mr. Thakrar's allocated psychologist at the beginning of November 2020, that's a 4 or so month period, I've had no contact with him. Mr. Thakrar has consistently ignored any attempts I have made to talk to or engage with him. Very difficult to think intelligently and creatively when the prisoner is saying, I'm not going to talk to you at all. Then over the page at 145, picking it up in the second passage, it reads as follows. On several occasions throughout the month, Kevin has had the Friday message delivered from Imam Vassi, to which he writes, false. Kevin did not respond when the Imam asked him about his health and how he was, false. This rude behaviour is also documented when staff asked Kevin if he wanted to attend his monthly meeting, and also speaking with Dr. Kadri, and on both occasions he ignored staff leading up to the class. Nonsense. And I'm sorry if I'm going back to the point that we've put to one side, at least for the time being. I'm sure it would not be suggested by anybody that any of those matters had to be properly investigated as if in a disciplinary adjudication, even though not engaging and refusing to talk to an officer might technically be a disciplinary offence. Earlier on in the month, Kevin received news that his ex-partner wished to sever all contact and didn't want any further correspondence with Kevin. This was a trigger for Kevin and could possibly be a factor in the downturn stroke progression in his presentation and behaviour, all of which is said to be nonsense. Throughout the month, Kevin continued to display risk-related behaviours. His continued withdrawal from staff regime with his stance on ignoring or not engaging with any members of staff unless he wants or needs something. Toward the end of the month, a telephone conference was arranged with CMG in which Mr. Thakrar was discussed at length. Following the discussions, there was an agreement that he was to be removed from the unit and relocated in a designated cell in the Sutton segregation.
Sorry, who's CMG?
Central Management Group.
Thank
Sorry,
you.
there's a lot of evidence with different acronyms. Central
Yes.
Management Group.
That is different from the CSCMC.
Yes, there may be overlap in people who attend it, but it's a different internal body. Nonetheless, these are reports that are considered by the CSC Management Committee. The move follows a long period of disengagement from the regime and staff interaction, his rude and antisocial behaviour, and his obvious lack of motivation to progress. It also noted that his actions and behaviour were in fact having a negative impact on the progression of several of his peers. This, in conjunction with his recent threats to his prison offender manager on the telephone, has resulted in his removal from the unit. And again, in terms of the question, was he given the reasons? He was. Not only has he seen the letter on the 7th of April, he's seen this and he's commented on it. He obviously thinks it's all nonsense, but he's had the chance to comment on it. On the 7th of April, Mr. Thakrar was relocated to the segregation unit. Almost immediately, he demanded the attention of the staff by pressing his cell call bell, asking constant questions and demanding to speak to governors, stating that his relocation was illegal and he wanted to move cells. Following day, it's documented on Nomis that a member of staff had attended his door and the conversation soon became volatile, with Kevin stating that he will remain segregated and orchestrate his own move out of full Sutton. He made threats and blamed others, for his actions, accepting no responsibility whatsoever for his behaviour and statements. It's reported anonymous that Mr. Thakrar went on to make verbal threats to destroy extreme behaviour and take a life if necessary to get out of Full Sutton. And the evidence for that is, for your note, in the NOMIS records at Supplementary Bundle 344 to 345. Mr. Thakrar is on an open ACCT document and subject to back wall unlock procedures with all interactions recorded. On the 9th of April, so this is another incident, it's also documented that Mr. Thakrar disputed saying that he was taken off of his life, but said that he spoke about attempted murder and hostage taking. The minutes for this month are back in the bundle at page 138. Could I ask my lord and my lady to read? Well, let me show you the key passages to save time.
The document we've just been looking at,
Yes.
headed disclosable, is that in fact routinely disclosed
Yes.
to the President? Yeah.
Yes. So the decision is minuted at 138 to 139. Starts at top of one after the redacted passage relating to another prisoner. Very little, if any, engagement with the unit team. Whilst he's polite with officers when he's requesting something, the same can't be said when staff wish to speak to him regarding other matters. He displays the same disrespectful behaviour by ignoring them. He doesn't engage with any member of the clinical team, verbally or through written correspondence. And then on the facing page, update from this month. Largely repeats what I've already read out to you, so I'm not going to read it all out again. And then after the first passage, there's a passage that starts with a black box. Person X again went through the following points of the defensible decision making, very complex and challenging, not engaging with staff, will engage with regime but not services, threats to a member of staff, decision made to move to DC, best suited in a DC at this time, however at some stage he will need to be moved to a unit, representation submitted on his behalf via the independent monitoring board person and his solicitor. IMB stated he is happy with the way that the decision has been addressed, made and noted in the defensible log. IMB is happy with what has been done with Mr. Thakrar. As my lady and my lords will have picked up, the CSC meetings are regularly attended by members of the external scrutinising body, the independent monitoring board. Then can I take you to
Sorry, before we leave that, can you just tell me what the HCR 20 is?
It's a risk assessment tool, my lady. I don't think we've got a copy of it in the bundle, but it's a tool properly used by the prison service to assess prisoners' risk. Can I? I'm told it's not a prison service tool. It's a professional psychiatric assessment tool widely used both in the prison service and outside it.
Can I just ask that on the page 139, underneath the paragraph you've just read,
Yes.
and above HCR 20, is an icon with a letter.
I assume that's the representation.
So this is a printout from a computer document.
Yes.
To which there is this link to a letter. Is that a document we have in the bundle?
No, I expect it was the representations made on his behalf by his solicitors to the management committee.
Yes, but that's how informed.
Yeah.
We don't.
I don't think that. I can't remember whether it was in the bundle below.
There are a number of such
Yes.
icons going through.
Yes, we don't have them all in the bundle.
No, but yeah, they are representations. An opportunity to make representations was afforded to them
Every month.
In this and other manners.
Yes, and is taken by him and or his solicitors. You'll also see he's regularly offered the opportunity to attend monthly care and management plan meetings, and generally, if not always, refused to attend them.
I should have asked in the long paragraph on this page, reference to an ACCT being
Yes,
open. What's that?
It's a document. It's assessment control. What can you remember the acronym ACCT?
Assessment, care, custody and teamwork.
Assessment, care, custody, and teamwork. I think often when prisoners are at risk of either harming others or themselves, something called an open ACCT document is made live and has various precautions stated in it.
So what were the meetings that he
It's
was?
just self. I'm
It's
sorry. It's
self-harm,
just
yes.
self-harm, not harm to others.
It denotes prisoners thought to be especially vulnerable to self-harm, I think, in ACCT.
Yes.
I think that's right.
You say he was offered the opportunity to attend which meetings?
Care and management plan meetings. I'll come back to that if I may. Can I show you also page 148? Which is, sorry, is that the right one? No, that's not what I was showing you. No, that's what I wanted to show you from that month. So we then look at some documents from the next period, starting with page 150. We've already looked at page 150 and discussed whether level 1 meant level 1 unlawful, how many prisons were required, how many prison officers were required to unlock. Now I wanted to show you the passage at the lower part of the page from the psychology unit. Mr. Thakrar continues to refuse to meet with me. I have changed my offer of meetings to monthly. This falls in line with the process followed for other designated cell individuals. I think this was still during COVID. I am also offering the meeting by going to his door myself and asking him, following a complaint that he made regarding me, asking segregation officers to ask if he would like to meet. Despite this, Mr. Thakrar still does not wish to meet. And I use this as one small illustration of the point I have made earlier and will make again, that this is not the prison service and its multidisciplinary team simply saying it's our way or the highway. They are trying to do what they can to accommodate various complaints, various concerns, various demands that Mr. Thakrar has made, and still there's no movement from his side. And that is a pattern that we will see repeated over and again. We then turn forward to the feedback given to Mr. Thakrar at page 154.
Still the May report, is it?
Well, there's some anomaly about how the dates span out, because although sometimes reports are said to cover the period of May, sometimes they refer to events the previous month. This is April. Yes, this. Sorry.
I hesitate some. There has been we have tried to investigate this overnight. There is an anomaly between what is said to be May, for example, or November, often has a date on it in December, so the decision is at the end. So you have a period, but the actual decision is taken a few days later, etc. When you do that exercise, and my lords, my ladies, query overnight forced us all to go back through the documents and try to work out what was happening. That process did two things. We found the September and October 2021 decisions, and we can see dates for those decisions. But the consequence is we don't have decisions for May and June once you realise that the decision date, post date's the only one, because this is a May document, said to be a May document, but contains an April entry. So a May document you'd normally expect to have June, if that makes sense. It is clearer in the footnotes, but it is not a straightforward case.
Well, thank you all for the hard work you've been doing on this. I'm not sure that kind of difference in dates is going to make a difference in the great scheme of things.
My submission is going to be that even if because of the passage of time or whatever it might be, not every month has a complete record, and we found other documents overnight we're not putting before the court. We do want to put in fresh evidence. My overall submission is going to be that the inference to be drawn is that on each and every month, the management committee did properly consider that that he should remain segregated in a designated cell, and that he, at all material times, knew what their reasons were. And in that respect, I do rely upon the document at page 154. You may wish to read it all in due course. It repeats a lot of the matters we've already covered. But at the bottom of the page, 154, the committee agree that Kevin is currently appropriately located, and Kevin should make every effort to re-engage with the local team, including the change of psychologist while he is segregated, to help expedite an appropriate and positive onward move. Now, it's obvious, my lords, in my submission and my lady, that by currently appropriately located, they well understand he's in a designated cell, and they are identifying what he needs to do to progress out of that cell back to a unit. This is not just the CSC Management Committee saying he's broadly okay to be a Rule 46 prisoner, but we're not turning our mind to the question of segregation. They plainly are. Time is not going to permit me to go through each of the other ones. I will do my best to show you a selection.
Yes, well,
just as Mr. Armstrong did.
I really don't think it's going to be helpful to go to 20 separate decisions. And even if one or two are missing, so what? But give us a selection.
Let me give you a selection. May 2021, page 156. Starts.
Just to be clear, does he get to see the minutes?
No.
No.
So, page 156, Kevin Thakrar, DC, so designated cell. Top of page 157, in order for Mr. Thakrar to progress, in other words, progress out of a designated cell, he needs to re-engage with the local multidisciplinary team and to take up on the offered psychology sessions with a view to reducing the risk he currently presents before overall risk reduction can be addressed in line with his care and management plan. He is appropriately placed in the CSC estate at this time. Mr. Armstrong's submission in his skeleton argument, though I don't think repeated in this extreme way in his oral submission, was that there was only one meeting in the whole 2-year period, I think she said was at some point in the middle of 2022, where the committee itself even considered the question of Mr. Thakrar's ongoing segregation from other prisoners, because it didn't. Because these documents, he says, don't expressly split it out in that way. But again, it's, in my respectful submission, unreal to suggest that the committee did not have well in mind the fact that he was in a designated cell, as it said at the beginning of 156. What it was turning its mind to in terms of how he might progress beyond that. Those minutes.
The actual decision was 158.
Yes, I endorse the recommendations. Yes.
And authorise continuing placement of the above mentioned offenders pursuant to PR 46.
Yes, and PR 46 encompasses, but under 46.3, the question of segregation with other prisoners.
It's not saying that. It doesn't mean to say that this detention of the segregated cell became unlawful because it wasn't authorised, but the actual decision is not, I endorse his being kept within a designated cell. It's, I endorse and authorise continuing placement pursuant to PR 46.
But the placement includes in a designated cell under 46, because it's not been appropriate to exercise the 46.3 power to allow him to reassociate with other prisoners. So I would not, A, I rely upon the substance of 156 to 157 in terms of what it is that they were actually deciding, and B, I wouldn't accept that 158 only extends to the 46(1) question. Then 163, which is within the June 2021 report period. Second line towards the end, Mr. Thakrar has been provided with a copy of the HCR 20 by his allocated psychologist, who was offered an opportunity for discussion. Mr. Thakrar declined to interact with her. Full Sutton continued to recommend transfer to another unit to allow Mr. Thakrar access to an alternative MDT. So again, going back to Mr. Armstrong's intelligent thinking, or cars in a car park, or things just need to nudge. There was already, before the move to Belmarsh, a recognition of the desirability of trying to shift things along by giving him a new MDT with whom to interact. Continuing, it says in the pre-penultimate line, continuing to impact on others in the unit. Full Sutton advised that his CAT A review is due in the near future. He still doesn't engage with the full MDT and must demonstrate this to progress through the estate. He is suitably placed at this moment in time. In other words, suitably placed in a DC. And again, Mr. Thakrar would have seen this. The minutes.
When you say progress through the CSC estate, must mean from designated cell
To a unit with a mixed unlock, potentially.
mixed unlock, because this is not considering whether you should be taken out.
It's not just, it's certainly not just considering
out
that.
of all those after all these years.
Yeah, indeed.
Yeah.
165, please, minutes from June 2021. Third line down in the non-redacted passage on 165. Reads, partway through the month, he made threats on multiple days towards staff, resulting in him being placed on back wall unlock. Last line, he is suitably located at Full Sutton in a designated cell at this stage. That's 165, paragraph 2. So I draw particular emphasis on the third sentence starting 3 lines down, reference to threats on multiple days towards staff, and then the express reference to him being suitably located at a DC at this stage. Can I then go forward, please, to July 2021, start with the minutes at 176. Again, page 176 is a reference to Mr. Thakrar declining to interact with his allocated psychologist. Full Sutton continuing to recommend a transfer to another unit. Last line on 176, Mr. Thakrar still doesn't engage with the full MDT, must demonstrate this to progress through the estate, he's suitably placed. And then under planned progressive moves on the facing page, transfer to Belmarsh DC to offer him a chance to engage with a different multidisciplinary team. So there is a coinciding of reasons for the move specifically to Belmarsh. Reason 1, which had always been in the offing, was he's not engaging with the Full Sutton multidisciplinary team. So we need to try and move the car in the car park along a bit and offer him a chance to do something with a different MDT elsewhere. And then that's in conjunction with the request from his solicitors that I'll be showing you to move to a location to allow him to be produced at the court for his trial.
It does seem to have been an HCR 20 completed then.
Can my lady just show me the?
Sorry, the first page you showed us.
Mr. Thakrar has been provided with the copy of the ECHR 20 by his psychologist. Is my lady inferring from that he completed it himself?
I'm inferring from that it has been completed and that his allocated psychologist has offered an opportunity for discussion, which he declined.
I think it was done in absence of
My learned junior thinks it was done without his input, but we will double check.
Anyway, it's a risk assessment document.
Sorry, is my lady saying it's a risk assessment document and therefore it was sufficient for the committee? Is the inference from my lady's observation that it was sufficient for without his engagement, for the committee properly to assess his risk?
I don't know how HC20s are required. I just see a reference to something that is a risk assessment document in the minutes,
Yes.
which you've shown to us, that's all.
Yes, I'm grateful.
I mean, perhaps regarding the HCR 20, implies there is one.
Yes, I'll take.
Are we over-interpreting?
I'll take instructions, or rather, I'll ask Melody to find the reference. So, as you know, there's then a move to Belmarsh in August of 2021. Could I invite you just to put the supplementary bundle to one side for a second and go back to the judgment below? Core bundle, tab 9, paragraphs 71 to 78. Could you just pick it up, please, at 73? The claimant asked that we move to Belmarsh. His solicitors did ask that he be able to attend court. He appears to deny making such a request. And then the judge finds essentially the request was made by his solicitors. And if you read 73 to 78 in particular, my respectful point is that these are findings of fact from which there has been no appeal.
And I think we know that at Belmarsh there is no CSC, so the only place you can be detained at Belmarsh
Is a
within the
DC.
CSC estate is in a designated cell,
My lady is correct.
which is segregated. It just is, because that's
Yes.
how a designated cell operates.
Yes. I've even visited it for another case. The reasons for the move to Belmarsh are spelled out in a letter to him. I'm not sure we've looked at this yet. Supplementary bundle, page 120.
Supplementary 120.
Yeah, supplementary tab 5, 120. Heading, this is the 8th of October 2021. Heading, your ongoing pathway. We are writing to you at the request of Alex Worthing, who during a recent visit to Belmarsh spoke to you about the above topic, in other words, your ongoing pathway. As previously stated by your legal team, you have requested a transfer from Full Sutton due to a breakdown in communication with the local MDT. Central Management Group found a suitable location at Belmarsh in a designated cell to facilitate a different MDT approach and assist with your upcoming court case. For you to progress within the estate, we require you to fully engage with the local MDT, so you can give it another chance. It's with a new MDT who's got to engage with it, and your named psychologist. We recognise that you perceived a breakdown with the team at Full Sutton, and we will look to move you to a suitable location in due course. So again, telling him what he's got to do, who he's got to engage with. Once your court case has been concluded, we will consider a move to another CSC unit. CMG will ensure that all information regarding risk to you and others, including non-associations, is considered prior to this move. And I'll show you in due course a little later on what was called a movement options paper that did precisely that some months afterwards. We must reinforce that your engagement is a key decision in your location, and we will consider all options, including the use of the DC of another establishment, should you choose not to engage, as per the operating manual. And over the page, for clarity, CMG are advising you to engage with the CMP process and work towards the following targets. Engage with the local MDT and in psychology sessions that have been offered. For risk reduction, for an assessment of risk of violence to be completed to inform core risk reduction work. Whilst the recent risk assessment was completed, we would encourage you to collaborate in a review of the assessment, given that this had to be completed without your direct input.
Must be the reference.
Must be the reference, yes. This will also inform an updated case formulation, add to a more developed understanding of your needs. And finally, engage in the HMPPS Commission Psychiatric Assessment. That's with Professor Grubin, I beg your pardon, as previously recommended. So again, the pleaded case, both below and in this appeal, that Mr. Thakrar did not have the reasons why he was being continually segregated are impossible to reconcile with the contemporaneous documents. And for your note, and I'll come back to it when we get to the relevant point in the chronology, these reasons are then repeated in other letters to him in April 2022 and in August 2022, as we see from pages SB 122 to 124. But I'll take you back to those letters and we'll get to the right part of the chronology. Again, as before, I'm not going to take you through all the CSC documents once he went to Belmarsh. Can we start, please, with September 2021, which was in the bundle below, was inadvertently missed out by the appellant solicitors. There's no criticism made, these things happen. From the supplementary bundle. Could my learned friend just hand up September and October 2021? Oh, we've got copies too, okay.
September. That's October.
I'll only be taking you to September for now.
That's September.
Thank you. Shall we put them in?
Yes, I've slotted them in. I did it this morning. I'm now going to tell you where I put them.
They've got numbers on them.
Yeah, that's the High Court bundle.
I see.
I have put them in after page 196 of the supplementary bundle because that's where they fit. And all I want to show you is paginated page 569. Which is the wrong pagination for present purposes, but will suffice. Last paragraph.
What are we looking at here?
This is
the feedback.
feedback to the prisoner in that month
At Belmarsh.
at Belmarsh. Last paragraph on that page 569. Mr. Thakrar's location at Belmarsh was facilitated following a request from his solicitor for an impending court case and to engage with a fresh team. False, says Mr. Thakrar. The committee recommend that Mr. Thakrar continues to build appropriate relationships with the local team. Nonsense. says Mr. Thakrar, and engage in his due care and management plan to help plot an appropriate pathway from Belmarsh. I'm sorry to bang on about the nonsense and the false, but this is not a man keen to help himself or the prison service. Everything they offer him is nonsense or false or ignored. Jumping forward, please, to November 2021, minutes at 2:05 to 2:06.
Just a moment.
If you pick it up at 2:05, 4 lines down, Mr. Thakrar continues to raise questions about his progression pathway out of the CSC. CMG have written to him to address this as below. He's suitably placed within the CSC as he refuses to engage fully with all services provided they are regarding his welfare, as he feels they are not beneficial. He continues a pattern of non-engagement with all services available to him, and we are unable to fully assess his level of custodial risk with a view to see it decreased to a point where he could be housed outside the CSC estate as per the policy. Mr. Thakrar is in a separate consideration. Mr. Thakrar is in a designated cell as he requested to move out of full supplement. He doesn't engage in the CSC process, and his legal team requested that he is located in an establishment near the court holding his case. We've written to Mr. Thakrar and explained to him how he can progress, and when he is at that point, we will discuss options for UNIT that can best assist him with his journey through the CSC system. So again, it's, in my respectful submission, hopeless for my learned friend to argue, as he does, that no separate consideration is being given to the question of segregation in a cell away from other prisoners. All of this is conveyed to Mr. Thakrar. We see that at 211. I'm not going to read it all out now. It includes essentially a repetition of exactly the passages I've just shown you.
You've just shown us the minutes,
Yes,
which he doesn't
but
see.
he does see this, and it's essentially it's the same.
Sorry, I'm a bit confused by the.
I showed you the minutes at 2:05, which he doesn't see, and I'm now showing you the feedback, which he does see and comment on, and they're essentially the same.
I'm sorry, I'm sure it's most. Just talk us through what's the timetable for report minutes feedback? How does it go?
My understanding, and I'll be, if shakes of the head happen behind me, I'll
see them before you.
It's reports taken into account by committee, decision taken, recorded in minutes, feedback given to prisoner.
And the feedback is then recorded in
regular. If you look at 211,
yeah. And that's a separate. That's not part of the report. It's not part of the minutes. It's a third document. Is that right?
well, my understanding is there's a
It's all on a computer, isn't it?
there's a pro forma that's populated. You can see the date of the feedback. Can you see on page 212? It's signed 24th of the 11th, 2021, 8 days after CMC Management Committee. That gives you an understanding of the timeline, I hope.
Yeah. So report, minutes, feedback.
Yes. Whether the minutes are prepared the very same day as the meeting
Can we
doesn't matter.
can we be careful? Sorry, I feel like there's been a number of references to the minutes.
Yeah, but they're not disclosed to the
They
prisoner.
are not
Yeah, I've
disclosed.
said
but
that
my-
twice.
Well, but you also made the submission that the suggestion that he doesn't have reasons are not consistent with the contemporaneous documents. He doesn't get the minutes. They don't
But
contain.
he doesn't get the minutes, but he gets the feedback form and he gets letters and I mean, the idea that this is not a man who understands what he's being asked to do is hopeless. Sorry.
Well, you distinguish between minutes, which may go to what their actual reasons were,
Yes.
and the monthly review headed disclosable, which is disclosed, and
And includes the
those for
policy aim.
those for good or ill are the reasons given.
Yes, but you can't also ignore letters written to him following discussions
Yes.
with Mr. Worthman, for example, that spell out those reasons again.
Yeah.
So what we're now looking at is the feedback, record of the feedback.
Given to him, and the text in on page 211 in the feedback given to him
Pretty well lifted from the minutes.
I think I haven't checked this
Yeah.
No,
entirely
haven't
copied
done
and
it.
pasted,
I've
did I?
done a line by line.
But my lady is
comparison.
right. They are lifted from the minutes.
Yeah.
And you can again you can see what he makes of them from his manuscript annotations on the side. But again, he can see from the third paragraph on 211 that separate consideration has been given to why he is in a DC and what he needs to do to move out.
Has Dr. Chris Arty reported by this stage?
No.
When does
July
remind me what-
2022.
July 22.
I'll come back to Dr. Sati's report, in particular when I deal with the Article 8 challenge. May 2022, I'm just going to show you the feedback to him. Can we actually start at 248? This is one of the rare occasions in which Mr. Thakrar chooses to attend his CMP meeting. You can see that from the paragraph about 2/3 of the way down, 248, headed CSC Psychology Team. Does the court see that? Mr. Thakrar attended his CMP on the 3rd of May.
It says it in the third paragraph on that page as well.
Yes. His CMP target to engage with the local psychology team for wellbeing sessions was discussed. Mr. Thakrar said he sees no point in engaging with these as they are not specific to him, serve no purpose, and that his stay in the DC at Belmarsh isn't permanent. So he sees no point in investing in this work and he'll be moved on in the future. Last sentence in that section of the page. Psychology will continue to offer Mr. Thakrar the opportunity to engage in wellbeing sessions while he remains located in the DC. What more, I'm sorry to sound belligerent, what more should they have done? And over the page 249, you see the feedback given to him. Fourth line down in the last box on 249. He wants CMG to attend his CMP. He doesn't feel he has a clear pathway out of the CSC. He became defensive with staff during his CMP. He puts barriers in the way to anything that staff try to offer him. His legal representative was present and writing everything down. Some progress that has been made is the access to the psychological services team at Belmarsh, currently seen every other week through his cell door. However, it still remains a problem with the sharing of information between services. Alex Worsman stated that it's a very clear line that his pathway is described through his care and management plans. He needs to work on his risk, which is through the CMP process. GV advised that it's been made very clear to Mr. Thakrar what his pathway is, which is for him to engage in a forensic psychological assessment with Professor Grubin and what we need to do for him to progress from the CSC. If he wants to put barriers in the way, that is his choice. July 2022. Actually, can we look at... Can I just show you page 252? My lady asked yesterday whether the committee took into account in their reasons the ongoing relevance of what brought into the CSC regime in the first place.
Yeah, yeah.
Can you just look at 252?
This is the minutes for May, are they?
This is the minutes for May.
So is that the minutes from which the feedback we just looked at
It is, and the problem is that 249. I'm sorry to go back and forth. If you go back to 249, it runs out,
Yes, I noticed that.
but it's a copy and paste of the minutes again, because it tracks the minutes line for line that start at 252. And overnight we checked this. What I'm about to say, I have verified with my own eyes overnight, but I didn't think it necessary to put in an additional page. So the last missing lines on 249 are the text that you see in the minutes at 252. What I'm about to read to the court.
Seem identical.
It is
The
identical.
last 6 and a bit lines are missing.
Yes. And the last 6 and a bit lines can be seen on 252, last 6 and a bit lines. Blank stated that it's the risk of Kevin and the serious incident that brought him in to CSC. Blank updated that the incident at Franklin was appalling and massive harm to staff. If you look at the index offence, what the brothers committed together, their roles in that are very different. He is in the CSC for the seriousness of what he did. The fact he was acquitted due to mental health reasons is still present. He needs to make a choice as to engagement in addressing these issues. So that, I hope that answers my lady's question yesterday. And just because he wanted out, he would have seen that. Because he didn't see the minutes, but he did see their cut and paste at 249.
And Franklin is 2010.
Yes. Then July of 2022, minutes at 267. This goes to my, we're trying to think intelligently point. 267, right middle, any unredacted paragraph, 8 lines down. There's a line that ends in a blank box. Blank discussed, you can see that? Blank discussed the 2 options. Do you see that? That Belmarsh had proposed to Mr. Thakrar about him having access to psychology services based on their local risk assessment for what was safe to do. This was either for him to be seen in the adjudication room with operational staff supervising, or in gated interview facilities in the healthcare area. Mr. Thakrar has refused both, stating that the first option wouldn't be confidential and the second would trigger his PTSD. Blank advised that a third option could be considered. This would be a supplement to the existing proposal that Mr. Thakrar engage in an HMPPS commission psychiatric assessment of Professor Gruber. All of which, as Mr. Worsman's evidence made clear, he refused. So again, options offered, ways round suggested, persistent intransigence in response. Like, same point arising from the monthly review for August. If you could pick it up at 274. Right at the bottom of the page, last 2 lines. Mr. Thakrar declined to attend his CMP this month, which was his opportunity to understand the options available for him to access his well-being sessions being offered to him by HMPPS psychology. Can I just stop there? He's offered regular well-being sessions with a psychologist. Nothing to do with, well, not nothing to do with, but separate from the risk assessment process. He consistently declines to attend them. And I do say that is relevant when we come to assess the level of seriousness of the interference with his Article 8 rights. Because this is not a man who craves human company. Sorry, he's showing us something on the screen. All nonsense. COVID lockdown restricted access to all services. Well, I would respect to Mr. Thakrar not accept that, because it would be contradictory to the contemporaneous record that we've got here.
Yes, we're talking about August 2022.
22. I can't remember whether by then there was still a lockdown.
Things were
There wasn't a lockdown.
There was.
There had been I mean, it's a factor to bear in mind that there were periods of lockdown and COVID in the period you've been covering.
It's all a fog in my mind, I'm afraid, in terms of the time period when we were locked down and when we weren't. But anyway, whether or not there was a lockdown, he's being offered opportunities to engage in wellbeing sessions, and he's saying no. This isn't a man saying, I really need human company, and my being kept away from people is having a deleterious effect on my mental well-being. But instead, you see the top of page 275, due to Mr. Thakrar not engaging with the meeting, we were unable to talk him through about the proposed settings where these could safely be facilitated, and any thoughts he may have about how we could further support his engagement with this work. He's not engaging with it. Again, thinking creatively, offering solutions, all turned down. Feedback given to him at the end of the month,
Sorry,
278.
this report is shown to him, it's just that I don't see the usual comments down.
Yes, well, I suspect that sometimes the version that became disclosed wasn't the version in which he had written his comment.
I see, okay. But these reports are shown to him.
They are shown to him. As is the next page I'm going to show you.
Well, before we leave that,
Yes.
perhaps it's pertinent to note on page 275.
Yes.
That he is suitably middle of the section, suitably located at HMP Belmarsh at present, and there is no recommendation to progress Mr. Thakrar
Within or outside
of the CSC estate.
Indeed so,
If you
and
were
that's
able to
then,
engage, this would be progress against the CSC pathway, something to be put forward to the CMT.
my lady is right to point that out.
First, brilliant.
And that does suggest a separate consideration of segregation.
It does.
there's a very full response on the following page. It's not marginal annotations, but
Yes. He's clearly seen what's being said and is responding to it. And then 278 also reflects the observation my lady just made. Feedback to prisoner. Mr. Thakrar is located in a designated cell at Belmarsh. There have been fluctuations in his levels of engagement since his arrival. We've seen more interaction since he was at Full Sutton. He is suitably placed in a designated cell and as a Rule 46 prisoner, as he has outstanding targets and there are on his care and management plan. And there are avenues to explore around increased engagement with the local MDT to try and take forward. And then for the avoidance of doubt, if you go back, just to put it in its chronological context, to the letter that was written to him at SB 124, we are writing
Sorry, page 124.
124. We are writing in response to your representations.
I'm obviously looking at the wrong thing.
This is a letter to Mr. Thakrar dated the 19th of August 2022, supplementary bundle 124. We got different documents on this on the right.
Yeah.
Writing to you in response to the representations you made at the management committee meeting held on the 16th of August. I'm sorry you feel your response to your July representations were inaccurate and inadequate. I can reassure you we use accurate data. The central team have identified a clear pathway for you. I draw your attention back to the letter that we wrote to you on the 8th of October. And then there's a recitation of that letter, and that is the letter at 120 to 121. The second page of that August letter seems to be missing.
Yes, I was going to ask you.
Yeah.
Not there.
Again, Mr. Thakrar can have been in no doubt what was required.
By this time, Dr. Crisati has reported.
Yes, and as I say, I will be dealing with Dr. Crisati. The September decision minutes are at 287. Now September 2022. much the same. Picking it up at 287, line 4. Mr. Thakrar refusing to engage outstanding targets suitably placed within the estate. There's then a letter to him that we haven't looked at yet. 289. Could I ask you to, again, for some reason, my recollection is that all these letters were in full in the bundle below, but this is a slight criticism there. Anyway, it probably doesn't matter. If you just read to yourself 289.
There is earlier in the bundle 2015.
201.
2015 is a document that seems to be in the wrong part of the sequence.
Yes, Mr. Armstrong yesterday said, but I think he's wrong. that 201 was a 2021 document. It's not. It's correctly dated 2022. Mr. Armstrong accepts that he was wrong to say that it was the wrong edition.
Well, unless there's
We've now got
protest about it, can we move it to its?
It's appropriately located where it is in the bundle because it is indeed a 2021 document. Mr. Thakrar was wrong yesterday. Mr. Armstrong was wrong yesterday to say that that document was misdated. It's correctly dated and it's correctly located in its chronological place.
it's duplicated later.
And he's right.
September 2022. This is the document at page 289.
Yes, my Lord Justice Bean was asking about a different document.
I see.
Yeah. Can we?
In fact, it's a duplicate.
It is indeed a duplicate.
Right.
You know, I'm focusing on
289.
289.
Yes.
So this is the letter, or the first page of the letter,
Yes.
sent in response to the representations he'd made, which were considered at the meeting,
In September.
as we see on page 287, where X read out Mr. Thaklar's
Absolutely, my
representation.
Lord.
Right.
Yes.
Good. Thank you. This looks as though there may be a chunk on the second page we haven't got,
Yes.
as opposed to just counting.
There must be some passages on the second page. And again, it goes back to my lady's question. Was the continuing relevance of the 2010 incident raised? To which the answer is yes. See middle paragraphs of this letter. And Mr. Worsman's evidence that I read out to you yesterday, my lady, said in terms he's always declined to discuss that incident since it happened. So that's September.
This letter doesn't say, does it? We consider you are appropriately placed, or not on the page that we've got.
No, but that I suspect that's what comes in the second page, and that's the obvious position that the CMC is taking. But
Yeah. You got it.
I've asked for it. October 2022, report at 294. Parallel to the lower hole punch. Mr. Thakrar hasn't achieved any of his CMP targets. He doesn't engage with the process. He does not engage with psychology or any target set through the care and management plan. Declined to attend his most recent care and management plan. He's encouraged to continue engaging with operational staff and think about how he may feel comfortable contributing to his monthly reviews. Question, is the prisoner's current location suitable? Are the local MDT recommending progression within or outside the estate? Mr. Thakrar is suitably located at Belmarsh at present. There is no requirement for the local MDT to progress Mr. Thakrar within or outside the estate. So again, separate considerations both.
That's the second half.
Oh, great.
And it doesn't say.
Mr. Armstrong has found the second part of that missing
well done.
letter. Wellbeing sessions have been identified as a target on your CMP to enable easily accessed participation with psychological services. This can allow you to test out this working relationship and build trust in it, which can then be developed through your CMP into a more targeted bespoke session to support the understanding and mitigation of your risk and enable your progression through and out of the CSC system, an ambition we all hold for you. It's intelligent thinking, creative thinking, intransigence from the claimant.
Could we have a copy of
Mi-
that?
Yeah, of course.
Is that it? Or is
That's
there-
it. Mr. Armstrong says to me, as I'm no doubt he will say to you, it's not dealing with his segregation with respect, of course it is, progression through and out of the CSC system.
Whether you stay,
Look at page 294, which
whether
is
you stay in the
starts
CSE.
in the second hole punch. Currently located at HMP Belmarsh in a DC
Yes.
appropriately.
Yes,
DC is segregated. so
absolutely.
that is a consideration of segregation.
If Mr. Armstrong, if Mr. Wills or Mr. Lister could email that.
That's second page.
I have decided it's going to be called page 289A.
Thank you, Manu.
So that was the report. We were going to deal with the minutes.
Yes.
Which is earlier in the bank.
Yes,
I finally understood
They're-
that.
the minutes are at 290 to 291.
Yeah.
Yes.
Top of 291. Engagement still minimal, both staff and regime. Raising issues appropriately. Third monthly review that he's refused to engage in, including nil engagement with his care and management plan. X went through his submitted representations
For October.
for October.
So that was the representations which are mentioned in the previous minutes, which aren't attached, but to which the response to which the letter was written that you just read out.
Exactly.
Those are the icon on page 291 is said to be his October representations.
But the letter at 289 says we are writing to you in response to representations you made held on the 20th of September. So I don't think there's
Right,
a.
so I'm wrong.
I think my lord is wrong.
So these are more representations.
Yeah, I think there are representations almost every month.
Okay, I'm sorry.
That's okay.
Anyway, there they are.
There they are.
With a PDF this time, not a Word document.
Yeah.
It does say that he's been engaging with his NHS psychology team, completed step 1, whatever that is. Forward with step 2, as this would have to be facilitated outside of cell, and then presumably we come back to those two options which we've seen previously, either in a room with someone or through a screen which triggers his PTSD.
And you see, my lady, just parallel to the upper hole punch, Mr. Thakrar has declined the options given to him. He's asked to sit in a room with her on his own, which is not going to do. I don't, it's not said, and I'm sorry to sound like a public lawyer, it's not said that it was unlawful or irrational
Those conditions.
to impose a condition that he not be allowed to sit in a room with a female psychologist on his own. And then much the same for the remainder of the period. Just one last example. November 2022 minutes, page 301. Still not engaging, doesn't attend to CMP, won't speak to psychology, but is polite. Does see NHS staff during round, but only from outside his door.
Sorry, where are you reading from now?
301.
So these are the November minutes.
These are the November minutes. If you just read those two passages. The penultimate important point in the chronology is that in December 2022, as Mr. Worsman explains, there is a detailed paper prepared to consider various options for a possible move out of Belmarsh. That is at supplementary bundle, starting at page 447.
December. Is that?
December 2022. Movement options for Mr. Kevan Thakrar. Introduction. Mr. Thakrar is currently located at Belmarsh. He has shown some progression working with the NHS clinician. But at this point, Belmarsh is unable to progress this due to Mr. Thakrar's unwillingness to complete sessions with staff as he alleges it triggers his PTSD. We've discussed the following CSC units as potential locations for Mr. Thakrar: Whitemore, Woodhill, Wakefield, Fullsutton, Manchester, Franklin, as well as discussing the option of him remaining in Belmarsh. As part of the decision-making process, we have included a review of each establishment that Mr. Thakrar has previously been located at and any areas of concern that have arisen. Due to the length of time he has spent in the CSC system, he has a complex picture around him. Keep safes from staff, assault, litigation, and potential harm from his peers. I'd ask you in due course to read the whole of this document. That it goes through all the options carefully, thinking intelligently and creatively, or whatever adjective you want to use. And then concludes at page 450, bottom of the page. Mr. Thakrar remains at Belmarsh, as initially we saw some increased levels of engagement compared to his time spent on other units. He started some work with the NHS clinical psychologist. This appeared to go well. However, due to his reluctance to complete any work out of cell, he has been unable to progress further. He's also made multiple requests as to why he is in a DC and not on a unit. He's made several claims of bullying against staff and has started to target one particular segregation staff member. Mr. Thakrar has moved to HMP Woodhill. This is a single unlocked site that could house him safely whilst the local MDT build up some trust and rapport with Mr. Thakrar. There is additional mental health resource which could help HMPPS understand what reasonable adjustments could be made for his alleged PTSD. And then 3, Mr. Thakrar could move to Manchester, where he could be held on a single unlock until a small association group is found. However, this would involve several moves, in other words, of other prisoners out with whom he's had past difficulty, and put additional pressure on the estate. There is now additional support in the form of an additional psychologist. So again, creative, intelligent thinking, trying to help Mr. Thakrar, notwithstanding his intransigence.
Not a document which went to him.
Don't know.
Mr. Grandison.
No.
Shaking his head.
No. But it goes to the ground 4, ground 5, and ground 6 and 7 assertion that sufficient thought was not being given to what to do in the face of his intransigence. Probably it's really ground 6 and 7 under article. But I'd invite you to read the whole of that document carefully in due course. And then the last document to show you before I make some submissions is the minutes from February of the following year at 332 to 333. The last passage on 332, there's a blanked out passage with a slight sense of exasperation in the first sentence after the blanked out passage. Don't know how many more times we need to outline to him his placement in a CSC, but we do. And outline times this has been explained to him. Still, a planned move to Manchester. However, this is not to happen imminently. Manchester is still the identified move, but for a number of reasons it's under review. X stated he is referring to a report written by Y in 2014. The report's almost 9 years old. While we do consider its conclusions and recommendations, as with all Mr. Thakrar's other privately commissioned assessments, we need to consider these within the context of our own specialist assessments and how we can best meet his needs. And I do submit that is evidence of privately commissioned assessments, including that of Cresati, Dr. Cresati, being referred to. And then reading on, it's also worth highlighting that HMPPS treat Blank's conclusions with caution for a number of reasons outlined in a report written by Blank, and at the time which was provided to Mr. Thakrar's solicitor. And then over the page, CSC Management Committee feedback. Mr. Thakrar refuses to engage with psychology team, which would assist us in identifying its custodial risk. He still has outstanding targets, which he is unable, as on his CMP, as such, he's unable to demonstrate a reduction in his custodial risk from this referring incident, so he's to remain a PR46 prisoner. That's all I want to show you on the documents. With all that in mind, and turning back to my submissions on grounds 4 and 5, we submit...
Sorry, but nothing in there about the... And obviously he's still at Belmarsh and in a DC.
is it took some time to orchestrate the move of the other prisoners out of Manchester to allow him to slot in. So turning to my submissions on grounds 4 and 5, with that in mind, we submit that the judge was not only entitled to, but clearly correct to reach the factual conclusion that she did, that the Management Committee had conducted regular reviews of Mr. Thakrar's ongoing segregation in the designated cell, and that the reasons for the ongoing segregation had been properly explained to him. The conclusions to that effect were set out, as Mr. Armstrong rightly showed you, in the judgment at paragraphs 155 to 156 and 159. And although those paragraphs are pithily expressed, they can't be read in isolation from the preceding parts of the judgment. There is as you would expect, a narrative part of the judgment that I'd invite you to read in due course, that starts at paragraph 45, if we go back to it. Paragraph 45, page 118 of the core bundle. Unsurprisingly, given the time frame, the selection of documents in the bundles amounts to almost 3,000 pages of evidence. I was taken through all the relevant material carefully by counsel during the hearing, and I have read that and the balance of the material again with care. I'm not attempting to summarise or refer to all the documentation, but the learned judge does then, at various parts in her judgment, deal with the core, many of the core documents. See, for example, paragraph 60, where she cites the 7th of April letter. Paragraph 68, where she refers to recommendations in April 2021. Paragraph 70, where she refers to the CMC minutes of 18th of May 2021, etc. So in our respectful submission, she was not only entitled to, but correct to reach the conclusions that she did. A, that the committee had regularly and properly considered the question of Mr. Thakrar's segregation from other prisoners in a designated cell, and B, she was right to reach the conclusion that she did, that the reasons were regularly explained to him. For all those reasons, we invite you to dismiss grounds 4 and 5. And I now turn to grounds 6 and 7, both of which concern the Article 8 challenge. The starting point is that we accept, as we have done in our skeleton argument, that the judge should not have determined the claimant's Article 8 claim simply on the basis of the limited concession concerning the composition of the CSC panel, and specifically the fact that between October 2021 and January 2023, so some but not all of the relevant period, the panel included, the committee included in its membership an acting prison governor, contrary to the judgment of Lord Reed in Borgas. So we accept that the judge should in any event have gone on to determine the question of whether Mr. Thakrar's segregation under Article 8 was justified. But as we said in our respondent's notice at paragraph 5, and as we developed in our skeleton argument, the answer to the justification question is yes, it was justified.
Just a minute.
In our
I
respect,
don't think we've looked at the respondent's notice.
yes,
Page 47.
yes, it's the respondent's notice says at paragraph 5, the judge didn't err in rejecting the Article 8 claim insofar as it wasn't conceded, insofar as there was any interference with Mr. Thakrar's Article 8 rights in accordance with law, including for the reasons set out above, and a proportionate means of achieving the legitimate aim of securing the safe and orderly operation of the CSC system. And that's expanded upon in the skeleton argument.
Yes.
In our respectful submission, the proportionality question under Article 8 largely depends upon whether you accept my learned friend's core submission that Mr. Thakrar's refusal to engage in an assessment of his risk did not constitute a sufficient reason to maintain his segregation in a designated cell.
Say that again. Did not.
Did not constitute a sufficient reason to maintain his segregation in a designated cell. That's the core of Mr. Armstrong's case. He says it wasn't enough, and it didn't. As time went on, it became disproportionate. And we obviously invite you to reject that submission for several reasons, which I'm about to enumerate, but many of which I have, in terms of the facts, already covered under grounds 4 and 5. My first reason, in terms of the legal framework, is that the claimant's case under Article 8 entails challenging the expert risk evaluation carried out by the Management Committee, which, as I said before, have long-standing expertise in the evaluation of risk and the management of prisoners, and who have a wealth of information before them. And as I said at the start today, although we accept that it's for the court to decide for itself the proportionality question, it is entitled and indeed required to take into account the expertise of the primary decision maker. And support for that is in Schvidler Supreme Court Supplementary Authorities Bundle, paragraph 123. If the courts haven't had the chance to look at that paragraph, should I take you to it just for emphasis? Thank you.
123, 133.
123. So supplementary authorities,
Tab 4.
tab 4. No, that's the Court of Appeal. Tab 5. There's a long discussion in the judgment by Lady Rose and Lord Sales, starting at 1, just to put this part of the judgment in context. It starts at paragraph 120, which is at 282 of the supplementary bundle. Just to show you a couple of passages in paragraph 120. The Court of Appeal stated the law in relation to the assessment of proportionality correctly. Well established that the court has to make its own assessment whether a measure is proportionate to a legitimate aim. If a measure is not proportionate, it will be incompatible with the relevant conventional rights. The question of whether the action taken by the public authority is lawful or not is what the court has to decide on a challenge. As Lord Justice Singh put it in this case, citing the Belfast City and Misbehaving judgment, the question whether an act is incompatible with a convention right is a question of substance for the court itself to decide. The court's function is not the conventional one in public law of reviewing the process by which the public authority reached its decision. As Lord Hoffman explained, the question is whether there has actually been a violation of convention rights, and not whether the decision maker properly considered the question of whether the rights would have been violated or not.
Do you accept that since Mrs. Justice McGowan didn't make a decision, we have to?
Entirely, my lord. She should have, she did not, you should. Can I also, however, show you what your approach should be to taking into account, in that context, the decisions of the Management Committee? And that's why I drew attention to paragraph 123, bottom of 283. This account of the law explains how it is that in the context of the proportionality assessment to be carried out by the court, i.e. you, there is room for appropriate respect and weight to be given to the views of the executive or the legislature as to how the balance between interests of the individual and of the general community should be struck.
Please forgive me, which paragraph are we reading from?
123.
I'm so sorry.
It's really the last sentence of para 122 going into 123.
Yes. And in particular, my lady and my lords, it's the last sentence of 123. The court is entitled to attach special weight to the judgments and assessments of a primary decision maker with special institutional competence. And that's not as, sorry. Oh yes, and Mr. Molyneux rightly points out, and we would add, is required to do so.
Yes.
Thank you.
All right.
Yes.
And I do respectfully submit that the Management Committee does indeed have special institutional competence, and that's why I wanted you to look at Snedden, which we can just pick up at authorities, main authorities bundle, not supplementary, main authorities bundle, tab 18. Paragraph 27. judgment of Lady Chief Justice at page 661 of the bundle. Paragraph 27. So page supplementary, sorry, main authorities, tab 18, page 661. The Secretary of State, his department and agencies are also recognised as experts in the management of prisoners in the prison estate, including in the assessment of prisoner risk. In Gilbert, Lord Justice Sales, as he then was, said, the Secretary of State and his department and its agencies are also experts in the management of prisoners in the prison estate, including assessing prisoner risk when it is relevant to the wide range of decisions which such management may involve. The statutory regime recognises this. So the Management Committee in this case has special institutional competence to which you should give due weight, even though you are making a proportionality decision for yourself. That's the legal framework for your task. Turning to how it should be discharged, we submit that Mr. Thakrar's refusal to engage, in particular, but not only, with a risk assessment, was clearly a matter of very significant weight. This was a person who had shown a significant propensity for both actual and threatened violence, not just in the index offences of murder for which he was serving his life sentence of Thakrar, but also during his time in the prison estate, not only in the serious assaults on the 3 prison officers in 2010, but much more recently when he was placed in the designated cell in April 2021 following his threat to punch somebody in the face, and at various points thereafter, some of which I have shown you. The fact that since having been moved to the designated cell, he has not actually managed to carry out any of his threats, including to prison officers, or to repeat what he did in 2010, is a matter of very limited weight, given the highly regulated environment in which he has been detained. Set against that background, Mr. Thakrar's persistent refusal to engage and to allow the prison service's appointed psychologist to assess his risk, save on his own unacceptable terms, plainly justified him being kept segregated from other prisoners. My next point is that even if there was an obligation on the Secretary of State to think increasingly intensively, I'll use that word rather than intelligently, in the face of the intransigence, which we do not accept for the reasons I said at the beginning. In any event, on the facts, that is what had happened. Because as I have shown you, Mr. Thakrar was offered, over the relevant period of time, a wide range of possible options to accommodate his various demands, to encourage him to engage, and to facilitate an assessment of his risk. All of which he steadfastly refused to accept, instead insisting that whoever was appointed could only be appointed on his own devised consent form. I do need to say just a few words about that form. It's at page 428 of the supplementary bundle where it starts. There are so many problems with this form, it's difficult to know where to begin. I'm certainly not going to be able to point them all out, but can I just point out a handful?
Some supplementary bundles. Then.
428. So when you see the word I, the I is the psychologist who is to be appointed, and when you see the word you, that's Mr. Thakrar. So paragraph 3, I, blank, will always ensure that the sessions will always be on a one-to-one basis in fully open conditions without anyone else present or in earshot. If at any time I'm told this cannot be facilitated, I will make it known that I can't see you under any other circumstances and will raise objections to the interference restricting my access to you. I am aware that you have never...
I don't think you need read all this out. It's imposing conditions which the defendant is entitled to say we don't regard as acceptable. I don't think Mr. Armstrong is saying that the defendant is legally obliged to arrange for this form to be completed by anyone who's going to see it.
He did say several times that all of the matters required or demanded in this form were, his words, understandable given what he said was Mr. Thakrar's past mental condition, existing mental condition. So I won't read it out in full. Can I just make a limited number of points? First of all, where he says, paragraph 3, 5 lines down, I'm aware that you have never harmed or tried to harm a psychologist. Well, we've got evidence that is not correct. Paragraph 7 on page 428, as part of our therapeutic alliance, I will aim to provide a client-centered approach. I'll be mindful not to do anything that could cause you harm or impact upon your disability of PTSD. Well, that's prejudging whether he has PTSD or not. Paragraph 8, I'm aware that you have been appointed the clinical psychologist Dr. X by the MHRT due to your disability of severe complex PTSD with the intent of completing trauma therapy, that Dr. X has objected to your placement in segregation and stated that it's not ethical, safe or fair to conduct therapy within segregation at all or within closed conditions. This information will inform how, where and when I come to conduct the psychology sessions, etc., etc., all of which is dictating outcomes, misleading the person who's supposed to sign this statement, etc., etc. I won't go through it.
Why is there a reluctance on the part of the prison service to accept that a diagnosis of post-traumatic stress disorder? Is it because they haven't, their own psychologists haven't been allowed to see him in order to assess him for PTSD?
Can I show you the answer to that in Mr. Worsman's statement? It's supplementary volume tab 4. Page 101, paragraph 52. Line 5, starting towards the end of the line. In summary, a number of relevant assessments completed by mental health clinicians conclude that the claimant does not meet the criteria for PTSD, Dr. Moe 2010, Dr. Friedman 2016, or that he doesn't require PTSD treatment.
Are these privately commissioned ones?
No,
Yes, commissioned by him.
they're commissioned by him.
Commissioned by Mr. Thakrar?
Yes.
Yeah.
And then, however, there are numerous assessments that the claimant is privately commissioned that conclude that he does have PTSD. And then paragraph 53, while these external assessments are considered carefully by the local management teams, they can't displace the views of HMPPS psychologists. However, in order to try to make progress, again, trying to shift...
Yes, no, I've seen that.
Yes.
But the HMPPS psychologists are they identified in paragraph 52, or they're people that aren't identified at all?
Can I just check? I asked the question whether any of the named individuals know Freeman and
Yeah.
Mina. The answer we don't. I don't know.
know.
What I was told is that over time, a range of psychologists have assessed Mr. Armstrong wants to say something. Right. Mr. Armstrong says he is told that the first three, by which I think he means Dr. Moe, Dr.
Freedman and Mina.
are prison service psychologists.
Thank you.
Did Dr. Moe give evidence at the 2010 trial? As I see it's 2010. You don't know, or the answer's no.
Yes, I wouldn't want to speculate.
No.
It obviously wasn't. PTSD or not was obviously an issue, but I simply don't know who they put the report by.
Yes, sorry.
Can I, unless I can assist further on that point, just deal now, head on, with the significant reliance that Milena Friend places on the Dr. Craysati report. That report appears at tab 3. Again, I won't have time to go through it all. In our respectful submission, you've seen evidence that privately commissioned reports are considered by the management committee. There's Mr. Armstrong showed me a letter this morning, dated the 8th of August 2022, from a registered forensic psychologist at Belmarsh, written to Mr. Thakrar's solicitors. I'm sure he'll give you a copy. It says, "Dear Mr. King, am I right to confirm safe receipt and storage of the psychological assessment that was recently completed by Jacob Craysati? We will ensure it's fully considered in respect of Mr. Thakrar's case and as part of his care and management plan."
Yeah.
And it's also considered on the inferences, it's been considered by the committee as well.
My Lord's just, that was in response to my Lord Justice Baker's question about whether we had had correspondence after it was served in July. So that's why
Yes.
we were checking.
I'm good.
Thank you.
But even though it was considered, along with other privately commissioned reports, we do not accept that the management committee, in its expert risk assessment, was obliged to give any particular weight to it, nor do we accept that it would be appropriate for this court to do so in its own freestanding proportionality assessment. First of all, the report of Dr. Craysati and the instructions that led to it are very far indeed from being CPR compliant. Second of all, the report contains numerous errors, doubtless based on Mr. Thakrar's self-reporting. I'm not going to have time to go through it all. I've taken you to some passages.
You don't need to. You say there's no challenge to the integrity of this witness, but you haven't been told the full story.
No, indeed. Can I just show you a couple of passages? It will take me just a few minutes. Paragraph 44, page 64. In terms of the 2010 incident leading to a trial for 2 charges of attempted murder and 1 count of Section 18 GBH, the allegations subsequently proven false at court. That's not correct. But that follows directly from the instructions that you see at page 76 paragraph 4 on page 76. Leading question, do you agree with previous experts that Mr. Thakrar does not require continued detention under Rule 46 as a
Sorry,
CSE?
where are you reading from?
I'm reading from the questions drafted by the solicitor at page 76 of the supplementary bundle. Paragraph 4. Do you agree with previous experts that Mr. Thakrar doesn't require continued detention under Rule 46? And if so, please consider why making reference to the historic nature of the now disproven allegation which has led to his initial referral, if it has any relevance. So she's being told it was false. She buys the question that it was false. We know the problems with that. And I already made my submission yesterday on paragraph 77, page 72, where we respectfully submit it's a surprising conclusion for the doctor to reach, to say whether he wants to pursue therapy for his PTSD is entirely a matter for him. In circumstances where on his own case it was the PTSD that caused him to act as he did and stab somebody in the back, literally, the idea that it should be left up to him to decide whether he should be treated or not for that condition, if indeed he has it, is difficult.
Well, it depends what question one's asking. Of course he has the right to refuse treatment, but you say that that's not helpful if the question is one of risk management.
My lord, yes. My next point is that in deciding whether the segregation was disproportionate interference with Mr. Thakrar's Article 8 rights, it's obviously relevant that Mr. Thakrar was not, during his time either at Full Sutton or at Belmarsh, deprived of all human contact. I won't go back through the evidence before the court in the form of Mr. statement, which shows how many times he had contact with other people, both remotely on the phone and in person, and the evidence that he refused contact with well-being sessions, etc., etc. Can I finally, under this ground, Mr. Thakrar is saying something. Refuse to accept PTSD because does not fit criteria for hospital referral. Something I can't read the
Need for reasonableness.
Need for reasonableness.
Reasonable adjustment.
Reasonable adjustments.
Yeah.
Yeah.
Thank you.
Thank you. Can I now deal with a point that was are you pursuing the point in paragraph 64.5 in the skeleton, which is about the relevance of the fact that he was moved to Manchester account to associate? Yes. Okay. There's a
Sorry,
point.
just before you go on, Mr. Armstrong, are you going to have a chance to have a word with your client before you respond? Because there are obviously things that he wants to get across, and I'm anxious that he should have a proper opportunity through you to do that.
Yes. Well, as
It's
he's
clearly
just said.
something that he wants. Well, we're approaching lunchtime, and I hope maybe
Yes, I
you'll
hope
be
we can
able
do
to
it
get
over lunch then.
a chance to speak to him.
I think my London friend is going to finish by 1.
Yes.
And I'm going to.
No, I'm not going to finish all my submissions by 1. I haven't begun to deal with Article 3 or Article 14.
Well,
I mean, I'm going to need.
Zelensky, we're running out of time.
Indeed. And 3 is a hard deadline, isn't it?
Okay, well, can I very briefly deal with as much as I can?
Yes.
There's a point raised in my friend Skeleton that basically says, look at what happened once he moved to Manchester. He was allowed to associate with 1 or 2 other prisoners. That shows that it was always safe for him to do so because he hadn't even by then engaged in a risk assessment. The position is actually rather more nuanced than that, as you can see from the supplementary bundle, post-hearing submissions, paragraph 7 to 8, which I'd invite you to read in due course. But in any event, it doesn't follow that just because Mr. Thakrar was permitted for a short period of time to associate with 1 or 2 other prisoners at Belmarsh, following his move from Belmarsh, that the whole of the previous period was disproportionate. In effect, the appellant is seeking to have it both ways. He says the longer it goes on, the more intensively you have to justify the position, the more creative ways you have to come up with for allowing something. And yet when after 2 years steps are taken to allow him to associate with one or two other prisoners, he turns that round on his head and says, well, that shows that everything before was unlawful. That can't be right. And in that context, all I would ask you to have in mind is the approach to proportionality in this specific context, where Lord Reid in Bank Mellat says the mere fact that you can think of some other ways of dealing with a particular situation that might be characterised as less intrusive doesn't mean that the situation is disproportionate. And I'll give you the page references. It's Bank Mellat, Lord Reid, paragraph 75, and there are two judgments in the report. It's the second of the two. It's Bank Mellat number 2, paragraph 75, on supplementary bundle, page 143, and then that is echoed in the Court of Appeal by Lord Justice Singh in Shridler, supplementary bundle, Court of Appeal, paragraph 200 to 202. The only other point on ground 7, is the allegedly separate interference of forcing him to undergo a psychological risk assessment. Mr. Armstrong seeks to compare this case to the Vavrika case about forced vaccinations and fines if you don't comply. It's obviously a completely different set of facts. I don't accept that he is being forced to undertake a risk assessment. On the contrary, he's declined to do so. That's all I'm going to say about that ground. Turning then to ground 3, the procedural aspects of Article 3. First, although the judge did not expressly state that the requirements of regular reviews and reasons were satisfied specifically for the purposes of Article 3, you should not infer that she failed to turn her mind to that issue, in particular given her express reference to that requirement in her judgment at paragraph 141. Second, even if she did not turn her mind to the procedural aspects of Article 3, had she done so, she would inevitably have reached the same conclusions as she did in relation to the domestic requirements to have conducted regular reviews and for regular reasons. So put shortly, if grounds 4 and 5 fail, ground 3 fails too. Thirdly, and in any event, even if it could be shown that the committee did not every single month consider segregation separately from the wider appropriateness of him being held under the Rule 46 regime, it would not follow that there had been any breach of Article 3. There is no authority for the proposition that any failure to adhere to a domestic law requirement for the ongoing review of detention or the domestic law requirement for giving reasons entails a breach of Article 3, nor indeed, and this is an important point, is there any authority for the proposition that if the conditions of detention and their impact on a prisoner do not substantively meet the levels of severity sufficient to constitute a breach of Article 3, there will nonetheless be a breach of that provision for what amount to no more than procedural reasons. No Strasbourg authority says that, and the position is gainsayed by the Supreme Court judgment in Shaheen. I'll just give you the references in a second. But that considered whether the long-term segregation of a prisoner over 56 months under the Scottish equivalent legislation was a breach of Article 3. And Lord Reid's conclusion at paragraph 37 was that in all the circumstances, and despite various failures to adhere to a proper decision-making process, there was still no breach, even though for a prolonged period there had been no lawful authorisation for the detention under the rules at all. See
In breach
paragraph
of Article 3.
for Article 3. And that's paragraphs 28 to 29.
Or
So
Shahid.
Shahid. So I'd invite you to look at Shahid 28 to 29 and 37. The learned friend relies on Provenzano, which is about a mafioso. In that case, there was compelling evidence of a serious progressive decline in Mr. Provenzano's cognitive functioning over many years, in which he had been detained under a very restrictive regime in the Italian prison system, with little or no evidence that his mental health had been taken into account in deciding whether to continue the regime. And there was a limited finding of breach for a few months just before he died, from March 2016 to July 2016. And I'd invite you in due course to look at paragraphs 151, 153 and 157. And I would make 3 submissions on Provenzano. First, the extreme facts are mild from our case. Indeed, Mr. Armstrong doesn't contend that the judge was bound to find on the medical evidence before her that the ongoing segregation had any serious adverse impact on his mental health. Second, the court's judgment in Provenzano sets no particular standard about how often domestic prison authorities have to conduct a review. And third, Provenzano is not authority for any proposition that shortcomings in the domestic regime of review must entail a breach of Article 3. But that's what I want to say about ground 3.
Sorry, you rattled through that so quickly. What was your third point?
My third point was that Provenzano is not authority for the proposition that any shortcomings in the domestic regime of review entails a substantive breach of Article 3. I'm going to, given the time, leave grounds 1 and 2 to be dealt with by what we said in our written submissions.
Yeah.
I don't think I'm going to add much to it.
That leaves Article 14.
It does.
also,
I need to spend a bit more time.
as to Article 8, what do you say about Mr. Justice Ellenbogen's decision, Award, particularly paragraph 1?
Yes. It is true that in that case, Mr. Justice Ellenbogen, on different facts, but looking at the manual, said that the manual was insufficiently drew attention to the need for a separate decision-making process. Although there was below, as one of the grounds of challenge, a policy challenge to the policy in Article 8. Sorry, to the policy in the operating manual. It was said by my learned friend in their pleaded case, inherent in the manual is the risk of breach of Article 8. The judge dismissed that part of the claim, and there has been no appeal from that aspect of her decision. And in
Sorry,
so the lawfulness of the policy under Article 8 is not before this court in its statutory appellate function. And for the avoidance of doubt,
What do you mean by that?
well, I inferred from my Lord Justice Bean's question, what should we do? What should we, the Court of Appeal, do about the fact that in Awale, Mrs. Justice Ellenbogen held that the CSC operating manual was not sufficiently clear in drawing the need to have the stage 2 assessment, i.e. the designated, the segregation part of the assessment, and for that reason entailed a breach of Article 8. And my inference from what my Lord asked me was, what do you say about that? My answer is,
Lawfulness or otherwise of the operating manual is not for our consideration here. Wasn't before the judge below and is not for our
well, it
consideration.
was before the judge below. She made findings that there was no breach of Article 8 inherent in the manual, and there's been no appeal. And it's not even as if the notice of appeal was drafted before Awale. It was drafted after a
The
while.
Wiley was handed down after, before this judgment. wasn't it?
Precisely so. And indeed, I'll come on to deal with the relevance of Awali in terms of the pleaded case, which is Article 14, where there is a live appeal. Can I just show you? I need to
Follow there is a conflict of authority then between what Mrs. Justice Morgan said and what Mrs. Justice McGowan said.
Well, there's a conflict of decision. Leave aside the reasons. Mrs. Justice McGowan says there is no inherent risk of breach of Article 8 arising from the policy.
Which paragraph is that?
Paragraph 166 to 168, disposing of ground 6.
Yes, so just so that I understand it, your point is that it's no part of our job to look at the lawfulness of the policy. What we're doing is looking at what actually happened,
Exactly so. And
whether there was a breach in the light of what actually happened in terms of their decision-making process and what was reported to the.
absolutely. So even if, which I don't accept, there was a I know Mrs. Justice Ellenbogen said it wasn't as clear as it should have been, and on the fact of Awale's case, it was conceded there had been no review regularly or at all of the fact of his segregation from other prisoners. That was conceded by the Secretary of State. The main legal dispute was whether that had been required in the first place, which we accepted in our case had been required when we said had been discharged. So, for my part, on acting for the Secretary in this case, I don't accept that there is a necessary deficiency in the operating manual. But even if there was, as my lady has said, that's not the question before you. The question before you is there a breach of Article 8? Answer no, for the reasons I've just given. And insofar as the Article 14 case is concerned, I'm conscious of the time, I would just make one, I hope not too forensic point before I complete the submissions on this after lunch in short.
I need an hour.
You need an hour.
I do need an hour.
Well,
Finished early yesterday.
How long do you need for Article 14?
10 minutes.
Yes. Yeah. Do we continue?
Now.
Yes.
Should we do it now?
No time like the present.
Okay, no time.
Yes.
Right. Can I show you first, please, supplementary bundle, page 10. This is a note drafted by the claimant following Awale that says it has a direct bearing on ground 4 of the claim, see paragraph 4, and a direct bearing on ground 3 of the claim, see ground 6, and a direct bearing on relief, see paragraph 7. There is no suggestion at all that Awale was relevant, as Mr. Armstrong now suggests, to his Article 14 claim. So it's not surprising that the judge did not pick up that was the case. In any event, the reasons I will now canter through, we don't accept Article 14 litigation. Just again for the sake of form, permission was refused on this ground by Mr. Justice Ritchie on the papers. Permission has been refused on this ground by Mr. Justice McGowan. So the position before you is this is a renewed application for permission to appeal on this particular point. You may say arguable but dismiss, but you have to. I just want to draw your attention to the fact this is a ground that requires permission to argue. In my respectful submission, the complete answer to the Article 14 complaint, as the judge recognised, is that the groups of prisoners under Rules 45 and 46 are not in a comparable position, and the procedural differences between the two are not all one way, i.e. they are not all adverse to the cohort in which Mr. Thakrar belongs, only the Rule 46 cohort, and they are justifiable. And I'll spell that out as quickly as I can. First of all, the initial decision as to whether or not a prisoner should be placed under the regime under 46 is taken by the Management Committee following a very lengthy and detailed process, which I showed you earlier in the manual, 4-month process, by the committee, which has a wide-ranging level of expertise, and which contrasts with the initial decision to segregate a prisoner under Rule 45, taken by a single governor at a prison. Second, the structure of the renewal of authorisation under the two rules is different, but we don't accept the position under Rule 45 is inherently better. Can I just show you Rule 45? It's an authorities bundle tab 1.
Or the judgment.
All the judgments. Tab 2.
34.
So Rule 45 2 says that removal for more than 72 hours may be authorised by the governor in writing, who may authorise a further period of removal for up to 14 days. Such authority may be renewed by the governor for subsequent periods of up to 14 days. So the governor, albeit acting through the Segregation Review Board, can authorise removal for a fairly lengthy period of time. But once you get to 42 days, you need the leave of the Secretary of State. So the leave of the Secretary of State under the relevant policies is given by one person, a senior person within the prison service.
Segregation Review Board is a local.
Segregation Review Board is a local proxy for the governor. Secretary of State acts through a single individual. We set that out in our detailed grounds of defence. You'll note its core bundle.
All right, we'll find.
Yes, I'm grateful.
In both cases, both persons, it's one person, both the 14-day and the 14.
Now, the 14 days the governor,
Yes.
then renewal by the Segregation Review Board,
Yes. Sorry.
which is internal to the prison but acts on behalf of
Sorry.
the governor.
Thank you.
Secretary of State acts through a single individual.
Yes.
And
This is the Deputy Director
Deputy
of
Director.
Custody
All
Management
of
or
this is in your
something.
skeleton.
it's all in our skeleton. By contrast, in Rule 46, it's a wider range of individuals who act for the Secretary of State in the form of the CSC Management Committee, and they review things every month, not every 42 days. So I don't accept that the two positions are comparable. I don't accept the position for Rule 46 prisoners is worse than for Rule 45 prisoners. And in any event, as my lady has already rightly identified, even under Article 14, as well as under Article 8, if in fact the Management Committee has properly considered Mr. Thakrar's ongoing segregation under Rule 46, which is the subject of grounds 4 and 5. If you dismiss grounds 4 and 5, he can't succeed on Article 14 because there is no worse treatment of him, in fact, because of what is said by Mr. Justice Ellenbogen to be the shortcomings in the operating manual. And in any event, for the sake of completeness, I do not accept that the manual is as deficient as she says it is. Can I very briefly, in the last 3 minutes available to me, just show you a couple of passages of the manual. It's at Supplementary Bundle 396. There's a heading on 396 called Dynamic Risk Assessment Meeting, the DRAM. And over the page, at 397, under the heading Association, it requires the reader of the manual to consider whether somebody should be on routine mixed unlock or restricted singular unlock, so expressly considering the segregation question. And Mrs. Justice Ellenbogen's essential complaint is that was a decision being taken by the DRAM on a weekly basis and not by the management committee on a monthly basis. But that's, from my vision, wrong, certainly wrong on the facts of this case. A, because you've seen they did consider it on a monthly basis, and B, because what happens at the DRAM feeds into the CSC Management Committee. You can see that. I'm not going to take you through all the documents, just to give you a couple of examples. Supplementary bundle 259. Middle paragraph, this is the minutes in June 2022. Under the heading This Month's Update, last few lines in that middle passage. He's completed step 1 of psychology work. Next step to discuss further in DRAM next week as to if he can continue with step 2. Likewise, please, supplementary bundle, page 8, post-hearing submissions, paragraph 8. You can see this is where there's an evolution in the position of the risk management of Mr. Thakrar, where the no one-to-one psychology marker has been removed. Does the court see that? And that has followed a DRAM meeting. Although despite that marker being removed, once again, this is the last thing I want to point out. Mr. Thakrar still refused to engage. But again, the key point, which I've already made, it's the last thing I'm going to say, is if you are satisfied that the Management Committee did, in fact, regularly review the ongoing question of Mr. Thakrar's segregation, then the fact that, as was common ground, that in Awale they did not, and the fact that in Awale the judge found that the manual should have been clearer, does not get Mr. Thakrar home either on Article 8 or on Article 14. Those are our submissions.
Mr. Armstrong accepted that the Article 14 claim cannot succeed on its own. It must be taken with something else.
Yes, it has to come within the ambit of another one of the convention grounds.
Yeah.
I think below Mr. Armstrong said something like, if I don't get home on the others, it's difficult for me to get home on Article 14. But that's by the by. Unless I can assist the court.
Right, thank you very much.
Yes, thank you, Mel. Could I just very politely ask if I need to speak to Mr. Thakrar and we don't have much time? Is it okay to do it in here?
Yes, I mean, so far as with yesterday afternoon, I don't wish to exercise any control over what will. Mr. Kosinski and the Secretary of State's team will vacate the court, so will we and our judicial assistants. The floor is yours.
He'll get some lunch though, won't he?
Yes, we'll all need to try to do that. But yes.
No, you, I don't mind about you. Mr. Thakrar will get some lunch. I know that there are strict timings about lunch times.
No idea how that's going to be managed, but he clearly wants to speak to us. And,
Yes. Right.
It's fasting.
He's fasting.
He's fasting anyway, of course.
Yes. 2 o'clock.
Court rise in favour.
Aidan. He used to be here on the legal team speaking to him. There shouldn't be any news to the public. Oh, of course.
you don't have an objection to Jenny and my work experience?
No objection to
They were here yesterday.
work experience.
If they're in the law firm, I can't see what really.
If they're with you, that's
Yeah, you know they are with us, yeah.
You need to give us a second. Everyone needs to leave.
Regrets the care proceedings position.
I just need the live to end on YouTube as well.
Yeah,
grab
could
you
I,
something,
hang
because
on, let
I
me just
see
give
the
you,
next hour's going to be very busy.
thank you. Can I just,
Are you going to be alright if we stay in here over lunch?
Yeah, that's fine. I'll look this door anyways from the back, so that's fine.
you just take that?
Yes, I'll just
uh,
get one.
Just, you're presumably just going to press or something?
I will nip round the corner to prep. Yeah.
No, that's perfect. Could you just get me a flat white?
I can,
and
let
then
me write this
some
down.
kind of-
Actually, if I can get an espresso, single espresso.
No food.
If you get the chance to, if you see like a tuna and are you going to Pret?
Yeah, I'm going
I
to.
like a tuna. Can I give you some money?
I'll grab it.
Well,
Don't
no,
worry,
she's got my
we'll
card,
sort
it's
it out
I was
later.
gonna bring it.
Tuna. Just tuna and cucumber, or if
Yeah.
not, if you haven't got one, salmon and cheese.
Yeah.
That's all I need. Thank you very much.
And a double espresso.
Tuna and cucumber is also fine for me to keep it simple.
Okay.
But if they haven't got that, just like one of the cheese baguettes, cheese pickle baguettes.
You're making me hungry. And to drink some?
Just if you just get me a flat white, that'd be wonderful. Thanks, Sarah.
Any-
Sorry to.
No, not at all.
Totally
it's
inappropriate
really
use of
important
somebody
that
who's
you
on
get
work.
fed. Is, what's coming up is important. So
I am feeling slightly. I didn't get to bed until midnight.
I am pleased to be of some vague use, and I will see you shortly.
Thank you very much. Thanks, Jenny.
I'm going to leave it.
It's unmuted, so I think you can ask.
Kevin, can you see us?
Can you speak, Kevin? No,
Nick.
yeah, we can't hear him.